Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends, and thanks so much for coming to hang out with me today. It's Friday, October 18th, 2024. Today is day one of the Sarah Boone trial. And the camera's already up on Court TV, so we're going to get ready to go to Orange County, Florida. Who's excited? This is going to be good. Hi to Tennessee. Hello, Kathleen. Good morning. This is going to be good. Sarah Boone's not getting her snacks. I mean, like, really, what's the harm in giving the girl some snacks? You know, she's been sitting in jail for almost 5 years. Give the girl a Pop-Tart, right? Like, what's the big whoop? I don't know. I don't know why she can't have a snack, but I'm not the judge. I mean, she might get her last Pop-Tart, like, for however many years. If she goes to jail for prison, for life, or what have you, she may never get the opportunity to have another Pop-Tart again. So really, is it really that? No fruit cup? Is that what I know? No snacks for you. No snack for you. That is a Seinfeld reference. IYKYK. IYKYK, you guys. Wow, some crazy. Oh, thanks for liking the intro. The intro song was written and produced by an amazing viewer named Melissa, aka Turd Ferguson. She wrote that song for me a long time ago, and I finally got around to making a video for it. So that I just threw together. So it's a work in progress, but I think it's really fun. I like the song a lot. And thank you. And thank Melissa for that. I had two really interesting shows yesterday. The first show we did yesterday was a review of the Commonwealth's brief in the appeal for Karen Reed. Went over that entire brief, and then Bettero dropped another letter, and boy, was it a bombshell. Did you guys watch that show last night in the Aiden Carney case? Chelsea says, I might not feel like that about a lot of people, but Sarah, I'm not sad for her. Pop-Tarts, and don't forget the peppermints. I mean, listen, Shaylee, never turn down a mint. Never turn down a mint, Jerry. No, so for you. Sarah is a fruit cup. I've named this trial Boone's Farm, and I've got a picture of Boone's Farm Strawberry Hill on the thumbnail, because many of you may remember they still sell it. Can you believe they still sell it? And it's still only like $3.99 a bottle. Boone's Farm Strawberry Hill. They have different flavors now too, like watermelon and something else. I was very surprised to hear that. Good morning, Bayou Babe. Good morning. Oh, VK sir, yippee! We're so happy that you're here. So happy that you're all here. Hello, Ireland. Hello, Sharon McHugh. Turd Ferguson was one of my faves from SNL, says VK sir. Somber more than goofy day. Yes, rest in peace, Jorge Torres Jr. We will never forget that this is always about the victim And what happened was senseless and tragic. And we'll see if Sarah Boone can prove battered spouse defense. We'll see. She's going to have to testify. Oh, and here's the other thing, in case you haven't been following all the pretrial stuff, because we haven't had a chance to cover it, because there's been so much breaking news in other parts of the country, world. The Menendez press conference we covered. The Menendez brothers might have the ability to be resentenced in California. They've been in prison for something like over 30 years. And there was a press conference with Mark Garagos the other day. But Sarah Boone, this is going to be similar to the Robert Tellis trial that we watched, the Boss Baby trial in Las Vegas, because Sarah Boone is going to be able to testify in narrative fashion, which means she's going to ramble on. Ramble on, Rose. Ramble on, Led Zeppelin. Same thing. And the reason for that is because she's changed her story so many times that the judge does not want to allow her lawyer to ask her questions, because a lawyer is not allowed to suborn perjury. If he knows that his or her client is going to testify untruthfully, we're not allowed to do that ethically. And so it's going to be a narrative monologue from Sarah Boone, and Lord knows how long. Lord knows how long she's going to talk for. It could be days. It could be days. Good morning, Starshine. Oh, Law Junkie, did you see my Instagram story this morning? Is that where you got that from? I think in song lyrics. And this morning, after I went to the bus stop, I drove down to the water and I took a picture of the sunrise. And I put that song to it. Good morning, Starshine. Starshine, the earth says hello. And then when I was putting in my Instagram story the stream for today, I'm like, what song comes into my head? And the song that came into my head, tell me if you know where this is from. Cell Block Tango. He had it coming. He had it coming. He had it coming all along. Oh, my voice is very hoarse today. If you'd have been there, if you'd have seen it. That's it. It's from Chicago. Yeah, 70K. Thank you so much. Thank you, Azen. We hit 70K last night on the stream when Will LeGlaire was on the stream with me. It was very surprising and happy. I only started posting content on my channel in July of last year. So it's been about 15 months. So yes. Sure, behind the screen is saying, as the song popped into her head too. And she's climbing the stairway to prison. Give the girl a Pop-Tart, right, Susan? Like, really? Can we not give the girl a Pop-Tart? How much money are we spending on this public defender? And this is the 9th one, by the way. This is her 9th attorney. 8 attorneys made motions to be relieved because she's a pain in the ass. She's the client from hell. I love Chicago too. And I don't know, Kathy, if you've been here before. You're a cupcake. But I got sucked into every single version of the TikTok dance, or it's actually YouTube that I watch because I don't really watch TikTok, of oh yes, oh yes, oh yes, oh yes, they both, oh yes, they both reached for the gun for I've watched them all. And I fell in love in YouTube. I fell in YouTube love with the Dancing Weatherman. Do you guys know the Dancing Weatherman? And I wrote him an email. I said, would you come on my show? And he hasn't responded to me yet. But he's a New Yorker. He's like Fox streamer, weather guy. And he has a huge following on TikTok, Instagram, and also YouTube. And he does all these dances. And he's great. Do you guys know the Dancing Weatherman? It's fantastic. Good morning, Team Brittany. Sarah in Schwankenhora. Scott is probably busy changing his name to not the Scott in the phone report. Oh, that's right. The Celebrite extraction that we looked at last night in Bettero's latest bombshell letter were text messages between Scott somebody and Clarence Woods Emerson, the pseudonym of Aiden Carney, a.k.a. Turtle Boy. David Reese, Chicago. I took my wife to see it last year. Wasn't it amazing? On Broadway. Did you go to the Broadway version? Christy Brinkley was in that. when I saw it, I can't remember who played the leads, but I don't think I saw Christy Brinkley in it, but I would have. She's amazing. Christy Brinkley is like 70 and hashtag goals for being 70. She looks amazing. Good morning to Colorado. Good morning. Go Buffs. Go Buffs. At least it's going to be a regular game time this weekend. Last week was brutal, man. It was like a 10:15 p.m. kickoff in New York. The game didn't end until something like 2 a.m. and I fell asleep before it ended. I don't know if you're a Buffs fan, but we're playing Arizona tomorrow. Kickoff is 4 p.m. Eastern. Give them the old razzle dazzle, razzle dazzle 'em. Thank you, Amberlynn. And you know what song came on? Because I had it blasting in the car after that song came in my head, and I will listen to that soundtrack over and over 100 times. The song Mr. Cellophane, you know, Mr. Cellophane, like I'm see-through, like nobody sees me. It just reminds me of Lally Flop. Mr. Cellophane. Kind of funny. It did not beat Vinny. He's like 10,000 ahead of me. I think he's pushing 80. And I just hit 70. So I'm in case you don't know, I'm in a secret competition against Vinny Politan that he doesn't know anything about unless you guys told him. To beat him in subscribers for YouTube because he's got like a private YouTube channel. Let me see how many he has today. 80.1. Oh, you guys were slacking. 10,000 behind. So if you're here and you just want to be nice and do something nice for a girl today on the day after the full moon, just hit the subscribe button because it's free. That will help me in my personal quest to beat Vinny Politan. Weird thing going on over on his channel is they're co-streaming like his private channel on Court TV. And a lot of people have pointed out that after the Karen Reed case, they may have lost a lot of subscribers on Court TV because of their treatment and some of the guests that they've had on covering the Karen Reed case. Like they're picking their guests the way the MSP picks their confidential informants. If you know what I mean. Right? Oh, yes. Oh, yes. Oh, yes. He had it coming. He had it coming. It was a murder, but not a crime. He fell into my knife. He fell into my knife 10 times. It is her ninth. They're not, I don't think they're, oh, is this guy's pro bono? Yeah, Northwest, you're right. Because she wrote that article. I mean, that flyer that we looked at. She's a good artist. She's got great handwriting and some good ability to make signage. You know, maybe in prison she can write on the chalkboard she can do the menu, the chalkboard menu like they have in some restaurants with like drink specials and like the dinner specials. She has good handwriting for that. She definitely has something that she could do over there if she's convicted, because innocent until proven guilty, right? Right? Thank you, Cammie. Thanks, Cammie. You've been around for a long time. You're an OG. Yeah. Oh, Stephanie. Oh, Stephanie, you didn't watch? Stephanie, don't even tell me StreamYard is having trouble. It's having trouble. It's not letting me highlight your comment. Oh, okay. You're going to save the Better Part 3 letter for later in the day. It's fire. I don't want to give you any spoilers, but I'm going to give you some spoilers. Michael Marcy is into this far deeper than anybody ever realized. And he's the district attorney for Norfolk County. For those of you who don't know, this is on the Aiden Carney case, which also is inextricably intertwined with the Karen Reed persecution. Michael Marcy and his private emails, using private emails to correspond with judges, high-level court personnel regarding the restraining order that was denied Chris Albert against Aiden Carney. Private email server. What does that remind you of? Does it remind you of anyone? Thanks, Shelly. Says, I love you. And we'll together. Great dynamic. We have a lot of fun. We have a lot of fun. It's like an unlikely pairing, I think. I think a lot of people would never have guessed it, but we have really good banter, I think. Northwest says there were $45,000 in attorney's fees for previously appointed attorneys. Well, there were 8 of them, and this case has been going on for almost 5 years. So that's not even that much. Think about it. They paid Ken Mello something like $80,000 to be the special ADA prosecuting Turtle Boy, and Ken Mello, quite frankly, hasn't done anything. And now, based on the latest Better letter drop, Stephanie, I'll be interested to hear what you think. Mello just might have written his ticket to disbarment, if you ask me. This is major. Major. They extracted all of Aiden's phones all the way back in October of 2023, and they haven't given him back his devices yet because they've been lying to the court and telling the court, they got to get a taint team. They're not going to be able to look at the devices yet because, there could be attorney-client privilege information on there, but all kinds of stuff has come out, and Better came swinging with receipts like a wrecking ball and proved to the court that they've been misrepresenting to the court that they really did extract his devices all the way back in October of 2023. And they still have they won't give him his devices back, including laptops, iPads, phones, and all of his work product is on there. And he's a journalist. They call him a blogger because they want to try and insult him. But it's a problem for them, for Ken Mello and the new special ADA, or the interim special ADA, or his name's Cosgrove, the temporary, we don't even know. Is he he's like the understudy for Ken Mello because Ken Mello is MIA. Should get more than disbarment, says Kathy. It's possible. It is possible. Thanks, Bianca. A lot of you guys who are across the pond and in other parts of the world might not have seen it last night because it was very late. It was 9 p.m. that we did it here on the East Coast. And, I had mommy Uber duties. You know how it is, ladies. And men, too. Parenting doesn't take a holiday or a vacation. And sometimes you got to go pick up and drive places when you got to do other things. But I'm lucky enough to be here with 70,000 people who are kind enough to hit the subscribe button on my channel. And I'm here for you. Shayla, I hope he gets disbarred and some of these people get bigger consequences. Shame on them. Oh, man, mafia asshole. Coming for you, sweetie. Just like you came for me. It's going to be good. It is going to be good. Alana says, Better is my new hall pass. I have a secret crush. That's so cute. It's not secret now, but I just put it up on the screen and everyone knows. Everyone knows. Oh, Jenny Grace, thanks for helping me get through my hair and makeup routine, which is my absolute least favorite thing to do. Hope you get to go to the Rock and Roll Hall of Fame. Enjoy it if you do. I'm trying. Got to juggle some things around. It's tomorrow night. Tomorrow night in Cleveland, and Dave Matthews Band is finally being recognized for the stars that they are. Very, very exciting. Who else is being inducted? Let's check. Didn't even really look. Because all I care about is Dave. Even in you may have seen in my opening, my new video is a selfie of Dave Matthews took from Jones Beach, from the stage. He took a selfie of him and the crowd, and I'm right there with the peace sign. Here are the inductees into the 2024 Rock and Roll Hall of Fame. Oh, interesting. Glad we could help you through your hair and makeup. I really didn't get to it today, but whatever. It's early, you guys. Also being inducted, in addition to Dave Matthews Band, is Mary J. Blige, Cher, Foreigner, Kool and the Gang, Peter Frampton, Ozzy Osbourne, and A Tribe Called Quest. Then, receiving the Musical Excellence Awards, Jimmy Buffett, MC5, Dionne Warwick, Norman Whitfield. Dave Matthews Band is also being inducted, so that and performing. Oh, wait a second. Oh, so they're performing. Are they performing also? Yeah, they got to be performing. And they're also being inducted, so it's both. I guess when you're being inducted, you also get to perform. The Musical Influence Award, Alexis Korner, Korner, It's a dude. I don't know who that is. John Mayhall or Mayall, Mayall. Big Mama Thornton. That's interesting, right? Yeah, where is Ken Mello? They call him Mellow Yellow. Gen X chick. He has been mysteriously ill for eons. Is the story that he's ill, or he has an eye problem, as in he just can't see coming to court anymore? I don't know. Robbie Rope says, is it possible that Cosgrove thought he knew better as a retired judge, but was not given all the facts? Well, that's, in Bettero's latest bombshell letter, these Bettero letters are going to go down in history. It's like, some famous papers, some famous legal papers in the annals of Massachusetts, Norfolk County history. He did specifically say in his letter to Cosgrove, listen, we're not blaming you. We don't think you did anything wrong. We don't think you misrepresented anything to the court. But 100% Michael Morrissey did and Ken Mello did. And here's all the receipts. Because guess what? Detective Lieutenant Brian Tully was one of the usual suspects in, also handling the investigation of the murder of Officer John O'Keefe. And I think he was involved in Sandra Birchmore's case. He was also involved in Brian Walsh's case. Tully testified in front of a grand jury in March of 2024 that was intended to try and indict Karen Reed and Aidan Carney for conspiring and colluding to intimidate witnesses. That grand jury did not indict the ham sandwich. And Tully was the only witness, and Tully testified that he examined the contents of Aidan Carney's phones back in October of 2023. That is sworn testimony. He testified to it. He was the only witness that testified there. And it's a problem for Mello. It's a problem for Morrissey. It's a problem because we know that Michael Morrissey knows his Brady obligations based on those crazy paranoid letters that he started writing in May of 2023 to the U.S. Attorney's Office to try and find out what they were investigating. Hi, Carol. How are you not tired? I'm tired. I'm tired. Can you hear my voice? It's like there's a frog living in my throat, but I'm here for you. So tired this morning. I went down the rabbit hole of Twitter last night after the Bettero letter reading. Man, he's got them all abuzz. Oh, really? I didn't even have a chance. Although I couldn't fall asleep. I didn't fall asleep until like 4, and then I was up by 7. All right, let's take a look at our court personnel. Couple more court officer daddies. Oh, they're from the sheriff's department. Sorry, didn't mean to demote you to being a court officer, but continued corroboration of corruption. Oh, I like the alliteration there, Robbie Ropes. Hi, blessed 1611. I do think she's going to have shackles on her legs, but not on her hands. She has been permitted to wear street clothes, and that's totally fair as well. I think she should be able to. I think it's highly prejudicial when a defendant has to show up in, an orange scrubs or jumpsuit or, the striped prison outfit. I think that's highly prejudicial. And all defendants are entitled to have the right to wear street clothes. So we'll see what she's wearing today. Hi, little cupcake. Good morning, sunshine. During the Karen Reed trial, David Yannetti said, we are outraged that he lied to us. This court should be outraged that DA Morrissey lied to you. Yeah, that was prophetic. And now the killer bees, Bettero and Bradle, are double teaming, ganging up, joining the chorus of attorneys from not only Massachusetts, but now New York and LA, singing the song of Morrissey lied to us. Little cupcakes, that was so good, says Danielle Alexander. Good morning, Danielle. 13 flags. What is the chance she will end up representing herself halfway through the case? Can she still fire her attorney? Yeah, she can. Oh, yes. Oh, yes. Oh, yes. Um, didn't like Robert Tellis try to, or maybe he did, but yeah, you can fire your attorney at any time based on whatever, based on irreconcilable differences. And Robert Tellis's attorney, Robert Draskevich, his name is Robert Draskevich, right? Did make a motion to withdraw at the close of sentencing the other day. That was this week, right? Court TV's having audio issues. All right. Okay. Are they going to fix them? We're not behind on this, are we? No. Right on time. Get our closed captions ready. Hopefully the audio is better than sometimes it's bad, sometimes it's good. You never know what you're going to get. Court TV is like a box of chocolates. You never know what you're going to get. That's too easy. I would say name that movie, but it's just too easy. Yeah, she could fire her attorney if she wants to. Hey, Melissa. Thanks for tuning in from Australia. I feel you've been extra busy this week. I've spent more time with you than anyone else. I spent more time with you guys than my family, my kids. But it's okay because you know what? YouTube has become my job and I love it. I love it. Great commute, work when I want to. And this week there's been a lot of breaking news. And luckily I have the privilege of having a flexible schedule, enough so that I'm able to jump right on when things break. And that's what we're here for, right? That Menendez press conference was something else. It was really moving to hear from both sides of the Menendez family, from Kitty's family and from Jose's family, that they both stand behind the boys and that they know that they were violently and horrifically abused by Jose as children. And oh my gosh, there was one woman who got up, and I forgot if she was Kitty's sister or Jose's sister. She was in her 90s, I think. She got up, and it was heartbreaking to listen to. So sad. Did you guys hear it? You here with me? Hello, Mallory. Hello, Mallory. Hi, New York. New York in the chat. Okay, let's not talk about other streamers and what they're doing and where they're streaming from, because it kind of diverts the audience. But I have the Court TV feed up, so I'm gonna stick in here for a minute. And Law and Crime has the same feed. They're not gonna start the trial without cameras being up and ready. So we don't need to worry about that. Let's see, there's 1,898 people on watching Law and Crime, and let's see how many people are on Court TV. 5,357. Go tell some of those people to come over here. Why do we only have a little over 1,000 people? I'm just kidding. You shouldn't do that, but really you can if you want to. Mello, you have a problem. Oh, I love this community too, Kathy D. Aren't we fun? We're so fun. We have first of all, the best moderators on YouTube. So props to all of my moderators who keep the chat classy. Other streamers run their channels differently. I happen to run my channel with a no F-bomb policy, no dirty words, no cursing, because so many of my viewers, first of all, my demographic is like 80% 45 plus. And so many of my viewers like to watch true crime with their kids in the room with no headphones on, at work without headphones. And somebody once said to me, my 95-year-old mother, finally has a place to watch true crime where you keep it clean. And so it just kind of stayed like that. Not like I don't curse like a sailor when I'm not on the air, because sometimes I do, but it's the way we do it. And we thank the moderators for that because they keep it that way. Mike and M, Mello, you have a problem. Thanks, Danielle. I'm trying to understand how Boone can use self-defense when George was literally zipped in a suitcase. How was her life at risk when the guy could not get out? I don't understand that defense. She's going to say that he was so angry about being in that suitcase and she saw his fingers come through. She left enough for his fingers to poke through, or maybe even his whole hand. She keeps changing the story. So whatever she says on the stand is going to be a new one, probably. And then it came out that she hit his fingers or his whole hand with a baseball bat. So This is going to be wild. And they're not allowed to they're not allowed to bring in like evidence or talk about battered spouse too much until if and when she testifies about it. Although her attorney is allowed to open on it and talk about it in his opening. Carol, I have an over-under bet with myself that she will end up firing her lawyers before this is all over. You know what? That is a great poll, Carol. Let's do that poll. Let's do it. I'll put it up. Oh, images released from inside Liam Payne's hotel room. Oh, that's not going to be good. Let me put that on the watch later list. I'm really very sad about Liam Payne. Liam Payne tragically died the other day after falling from or jumping from or being pushed from a third-floor balcony in Argentina. He was one of the founding members of One Direction. Oh, wait, here comes Sarah. Oh, they're unshackling her belt chain. Oh, that chain belt might come back in fashion now. Actually, I do have a belt like that. Oh, it's vintage. I must have, I mean, I've probably had it for like 30 years, but it's a style. Might rock that again. I think I have a gold one and a silver one. Let's see. Pull. All right, poll is up. Will Sarah fire her attorney during the trial?
Bless you.
Yes or no? All right, let's do a fit check. Sarah Boone is rocking a black suit today over a what color would we call that? Like a cherry colored. Could be like a short sleeve sweater or a sweater of some sort with a crew neck. I did not notice if she was in a skirt or slacks. Did anybody notice that? She knows better not to fire him. Sonia says no because she wants someone else to blame if she's found guilty. Miss T is like, well, that's a no-brained answer too. But what do you think, Miss T? What's your vote? Tell us your vote and why you feel that way.
William J. for the state.
James Owens on behalf of Sarah Boone.
Tony Henderson, Sarah Boone. Kevin Beck there.
Fix your audio. She's raising her hand.
I do.
Oh, she's being sworn
Good
in.
morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right. Ms. Boone is seated at counsel's table, wearing a black suit and a pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to her person. So we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2 is identified in the defendant's fifth amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Most of them deal with just billings,
Find the mic, please.
observations by the medical personnel, so that necessarily apply to the issue of anxiety, as the court had
Of those 119 images, how many are being sought? 15? Okay, thank you. State response.
Apparently, these are all just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures that still not in a PDF form. So of the 15 pages, the first two that they list are pages 9 and 10 out of 111. And I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp. So I had to, I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those two pages. Pages 21, and then they skip 22, 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there's a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. We are going to have at least one medical doctor, well, two. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologists will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Mhm.
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment
Thank you.
of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48, and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time. Page 63.
What's 49?
On a Tuesday, Carrie.
So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was
Bless you.
tested, shows that she was tested for the presence of ethyl alcohol or ethanol but it doesn't give the results.
Are the results contained on another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete. and
But
not-
they are also seeking 49, correct?
Yes.
Thank you.
Just, they just skipped 48, just like they skipped 26.
Okay.
Page 63, it appears to be repetitive, but we don't have any particular objection. Page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018. So we don't object to that. So basically we're asking for pages 26 and 48 to be included.
Okay, thank you. The defense did, or I'm sorry, the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State, 369 Southern 3rd, 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records?
Judge, I did check with my secretary, Margaret, and my understanding is, I didn't know that was going to be a question about when we actually sent it out. I know it.
Margaret.
One of my trips down here, I got Sarah Boone to sign a medical release. We sent it to the hospital. It took.
Margaret getting a shout out on
We got it
TV.
last week.
Everybody say hi to
I
Margaret.
don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office.
Hello, Aiden in Dublin.
Whatever reason, the records did not get to Shelby, who was handling that issue until late. It was yesterday or the day before that she was aware that they had not been disclosed. We provided the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that some of the other lawyers, one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital. So we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yeah.
Okay. Anything else, sir?
If I may real quickly, based on the invoice that was sent from the Advance Building Department, apparently it's a separate subcontractor, the request was made on the 27th of September. I suspect they waited until they received confirmation of payment.
Oh, for the love of the traveling Mary, find this man a microphone.
So we received those. So it's all been within a couple of weeks, plus we had the hurricane issue last week, and I think there were issues as to the matter being provided for. I did speak
Ridiculous.
yesterday afternoon after I had a chance to look at the records, and I asked the extension what the matter or relationship to, and was told that they already had those records.
What is a Richardson hearing, you may ask? And I'll tell you, since we can't hear this attorney speaking anywhere.
Any further argument or positions with regard to the Richardson analysis, Mr. J?
That's for the purpose of this hearing, I'd like this stack of documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
Richardson hearing is held to determine whether there's been a violation of the discovery rules and what the appropriate remedy should be, whether to exclude the evidence, if it's egregious enough. And we just heard him rule.
There was just a reference that the 81 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please.
Oh, somebody's phone must have went
If you
off.
cannot follow the court's instructions
Get the hell
due
out.
to the publicity in this case, I will ask for you to be removed.
Oh, yeah.
Does everyone understand? Thank you. You may proceed.
And
I like this
I
judge.
realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was
Yes,
entered
sir.
as one, correct?
Yes, sir.
Thank
It
you.
is sub-labeled within these records as page 2 of 14. And it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that. And so I'm asking for the leeway to continue to try and search for that particular page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just at this point, I've not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119 page PDF and you make it word searchable, you just put in the magic word and it helps the attorney.
Word has entered the chat.
So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance of those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide information.
I appreciate y'all working together on that. So here's what we're going to do.
If I may.
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed. So they closed. So we were there at 8 o'clock to get the copy to the state. We had promised, but we will bring one at lunch to hand to state.
Okay. Appreciate it. All right. Any other argument with regard to the Richardson issue? Anything further, Mr. Beck? Okay. With regard to, let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages, 26 and 49 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that sought to be moved into evidence with regard to this January 23, 2018 incident is provided in the 119 pages of item 2 of the defendant's fifth amended reciprocal discovery exhibit list. I will not foreclose the state regarding page 68 of the 81 pages. If they were able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I have seen include jury instructions that may not be given and may not be given in the way that the court gives.
Oh, you can't do that.
Photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record.
Delay.
I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Judge, yeah, the defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force,
I'm not discussing the jury instructions at this time.
there are evidence of prior threats, prior events of violence committed under that instruction.
Is there really no mic at the?
Here's
no
my
mo-
concern.
No mic at the podium.
Why are we addressing law in opening statement?
Yeah, you're not supposed
I
to.
agree with the state attorney. I did close up a couple of these on the justifiable use of non-deadly force.
That still, that does
It's
not
for
answer
closing.
my question.
Not opening.
Not to use them.
An
Okay.
opening statement is intended to talk about what the evidence will show. The evidence will show this, that, and that. It's a statement. You don't talk about the law until you're closing because we don't know what they're going to be able to prove. And so we don't know what jury instructions are going to be given until the end of the trial. It is improper.
And opening is this common sense out upon
I can't hear him anyway, so I'll just.
speculative, imaginary, or forced doubt is the same instruction.
What's your position with regard to those two, Mr. J?
Judge, it's opening statements. We should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon.
Mhm.
We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions we're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may in fact read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Judge, I've been doing this 35 years. I've had these boards. I've used these boards in opening statements. I don't know how many times.
He's recycling his
I've said
boards.
that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started. And then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions in limine, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory. And I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please?
Yeah, I mean, here's how jury instructions work.
Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable.
You know where they didn't give an instruction on reasonable doubt, and it's part of the motion for a new trial, and then JNOV is in the Carly Gregg case in Mississippi. The judge said, no, we don't give instructions to the jury on reasonable doubt because every juror should know what reasonable doubt is. And you heard the definition of reasonable doubt, and I don't think that every potential juror knows that, and it should be instructed. But this attorney, sadly, is going to have to go back to Kinko's because he doesn't have the updated jury instruction on reasonable doubt. So there's that.
That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Judge, I'll have it redone in arguments.
As long as,
Those
I mean,
reasons.
we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
And this is an excerpt from.
I think the people sitting on either side of the judge are court personnel. Could be maybe his law secretary, could be maybe some interns that work in his office. Somebody asked who those people are that are sitting on both, two people on each side of the judge. Yeah, Kinko's. Does Kinko still exist, right? Liz Kohlbaker. OMG, stop this trial and take the plea. For the love of all that is holy and the traveling Mary. We can't hear him, so I'm just going to catch us up to real time.
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening remarks.
FedEx Kinko's, you're right.
6 through 10 are optional. We haven't decided which out of the optional instructions 6 through 10 we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law, you know, that in many ways.
You give it at the end of the
we
case
do
in your
it where we
closing
give them the law at
argument.
the very end, you know, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
I think for the record, we should mark them.
Okay.
I'm conflating this
Do you
with
want them
Delphi.
marked, you want them marked by Madam Clerk,
I
correct?
think it's 6
Okay,
jurors
so
because
let's
it's not a
approach
death
with that
penalty
first
case.
photograph, please.
And that's Florida rules.
Madam Clerk, yes.
If somebody in the chat can clarify that for me. I'm following too many trials at once. I know the Delphi jury is 8 women and 4 men. But in Florida, that's the rule. If it's not a capital case, it's a 6-person jury. Where is the court reporter? I think perhaps that is, she's behind the box. Yes, I think you might be right. Yes, she's marking the exhibits, so she is the court reporter. That is part of her duties. We'll call her the suitcase whisperer. I'll allow it. I'll allow it, shards of words. Good morning, Patty Olson. You think it's a full jury? It's not a death penalty case, though, right? I thought Florida rules was 6. All right, whoever knows, tell me. Battered spouse syndrome is unique to, I think, only Florida. And I'm very sorry that you were a victim, Karen. Let's call you a survivor because you're a warrior. They were not married, but you don't need to be married to use the defense. But in order to use the defense, you have to show that you were in imminent fear for your life at the time the murder was committed. So it's, in my opinion, it's going to be hard for her to prove that when this man was, George, was zipped into a suitcase and couldn't get out and said, Sarah, I can't breathe. Sarah, I can't breathe. I can't breathe. I can't breathe. And the videotapes of her taunting him while he's in the suitcase, I think are going to convict her. It does show a depraved heart. I mean, if there's any, if there's any definition of depraved heart, kind of think that's kind of what it is, but let's reserve judgment and see if she can prove that she was, in fact, a victim or survivor of DV. And in that case, I may change my opinion. Thanks, little cupcakes. There's no way. Jury needs instructions without assumption. They know anything without being told. Yeah. This opening by the defense is going to be very interesting, Jenny G. What are the, do you think that Sarah wrote the opening for him? I don't know. I think she might have. We're on real time now, so we don't have the luxury of skipping ahead. Morning, Wine Yogi. Kathy's going to make a shirt that says, go back to Kinko's. Every day we get like 10 shirt ideas. Oh, thanks. Love is a 4-letter word. Says she loves me. Nobody's worked harder than you have this week. Many thanks and much love and respect. Well, you know what, girl? Sis, I have two kids in college right now. You guys know how much college costs right now? It's insane. I'm never going to be able to retire, ever. 6 jurors with 8 alternates. That's interesting, your mom. So they did pick 12 altogether. So the last viewer wasn't wrong. They picked 12, but only 6 are sitting and 8 are alternating. Got it. Okay, and everyone, Wendy agrees. Northwest agrees, because I didn't watch jury selection. Hello, Scarlet Grace. This guy took the case for publicity, but not doing himself any favors. Second degree murder is 6-person. Right. It's only capital murder that gets you 12, right? Tell me this, my amazing collaborative chat. Do the alternates know that they're alternates yet? Different states do it differently, and I can't remember Florida. It's not always good if you know you're an alternate going in, because I find that alternates don't pay as much attention when they know that they may not be able to deliberate. They're not as invested. 5 women and 1 man. Northwest is coming in with all the deets. Thank you so much. We've discussed this in other cases, and in many cases, women are more judgmental than men. You know, we thought it would be good for Ashley Benefield. I think that she had the majority of women on her jury as well, and they convicted her really fast. They did not buy her defense of being in imminent fear for her life in the moments leading up to Doug Benefield's shooting. And if you compare Ashley Benefield's demeanor, appearance, speech patterns with Sarah Boone's, they're completely different, in my opinion. I know, Tara, me too. I would never want only 6 people deciding my fate. You're right. Carrie knows. She says, the opening, only what you expect the evidence will show.
photo.
Even all us non-lawyers know this. Amanda has a job now. Congrats, Amanda. She definitely has an AirPod at work in for this one. Love you too, girl. Right there, right back at you. Mods and cupcakes. Yes, Sarah. And Schwalk and Hora, the one person I missed in the Karen retrial, Madam Court Reporter. Madam Court Reporter. She was talking into that thing that looked like an athletic cup. It was such a weird device. What's up with that? What is up with the box? I don't know. What's in the box? Somebody's talking, but they have no mic. Okay, here's the thing. Okay, there's technology now. I'm just going to put this out there for the pool cameras in the house, Core TV, Law and Crime. They have wireless lapel mics that you could mic up the attorneys who are going to be speaking during this case. And you could actually have great sound. And you could even give them the opportunity to mute that mic when they're talking to their clients, so there's no hot mic moments or anything such as like that. The technology exists. Why don't we take advantage of it, peeps? Thank you. The quiet tone. ASMR. Diplomatic Diva. I don't think Sarah made the poster boards because he said he's used them in many trials. So he's recycling them. In fact, it wasn't even up to date with the most recent instruction on reasonable doubt. So it's out. I don't even know if they would give Sarah like, what do they call that stuff? The poster board? You know, like the science fair, like those science fair boards. How many moms in the chat had to go running around trying to find a science fair trifold board at the very last minute? And everybody's out. Michael's is out. Everybody's out. Those dopey science fair boards. Those science fair projects are more work for the parents than they are for the kids, if you ask me. In Massachusetts, yes, they call them chalks. New York, we call them trial exhibits. I don't even think they definitely wouldn't give her access to a glue gun. But there are companies that print them for you. Starbucks. I have coffee on the brain and I don't have enough of it. Kinko's is one. You're going to have to rely on the captions for now while he's talking. Sorry, guys. So far, they're pretty accurate. Except Sarah Boone is seraphim. Seraphim. Is that a word? I got to look it up. Hmm. Seraphims are celestial beings with wings that appear in Jewish, Christian, and Islamic literature. Did anybody know that? I mean, the fact that the AI picked Sarah Boone up as being a
Any other
seraphim.
further argument with regard to the use of those items pre-marked as A through I in opening statement, Mr. Owens?
Yes, Judge, and I sent you some cases.
When did you send it, sir?
This morning.
Court TV, fix
I have
it.
not received it.
Seraphim is an angel. Okay. Okay. Except according to Google AI, it says seraphim are often described as having 2 or 3 pairs of wings. So I don't know that they're good angels.
I think you were already on the bench, so we sent
In the Christian religion, they are the highest ranking
State, can you
celestial
copy of it?
beings in the hierarchy of
I'm
angels.
familiar with the case law. I did receive the email. I'm not sure if it indicated who all was copied on it. A separate one, but I'll check.
Is it just these 2 cases? I've been provided Alsager v. State, 326 Southern 3rd, 656, Florida Supreme Court, 2021. Low v. State, 259 Southern 3rd, 23, Florida Supreme Court, 2018. Yes, sir.
Judge, the court has discretion to allow demonstrative aids. If you look at one or both of those, there was a state one.
Funny but not funny. Demonstrative aids, they capitalized aids, all in caps, as in the disease. All right, somebody needs to get a better program for closed captions.
A dummy they were using in a homicide case, which the court allowed. Other cases have allowed photographs and demonstrative aids to be used in opening statements.
That's right, Team Brittany. Moms of twins unite.
In the
Oh, by the way, my poster's due
Alcaguer
tomorrow.
case, which is the 2021 case, trial court acted within its discretion in permitting state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that wasn't in the record.
Seraphim and cherubim. I went through a cherub phase.
2018 case,
Cherubs.
Supreme Court of Florida.
A lot of cherub.
Again, the trial
Art.
court acted within its discretion in allowing a
90s.
demonstrative exhibit. In that case, it was a murder prosecution. Trial court acted within its discretion in allowing the state to use a mannequin in a demonstrative aid in order to show the position of the gun in relation to the victim's body.
I would love it if you'd use a mannequin and put it in a suitcase. I mean, listen, we got to keep it light sometimes, right?
The mannequin was used to demonstrate the location of the gunshot wounds, the angle of the impact against the skin.
Or as a demonstrative aid, get a person the same size as George and have them crawl into a
Sizing of the
suitcase.
trajectories were anatomical,
The
not
suitcase.
spatial, and had a small degree of error where only was slight difference between the victim's size and the mannequin's dimensions. There was nothing to suggest the mannequin was altered to resemble the victim. Court allowed, again, the court's discretion. As you know, we're claiming self-defense, and as part of that instruction, we're entitled to allege prior instances of difficulties and prior acts of violence so that the defendant.
Look at Owens bringing in the actual case law.
Self-defense. Your state of mind is different from the norm.
Oh, stop it. Come on, man. Diplomatic Diva for their win so far. It's a boom box, kind of like the boom box from the 80s, but sound quality not as good. Who remembers the boom boxes we used to bring to Roosevelt Field, the mall? On the bus. We would take the bus to Roosevelt Field, bring in the boom box every time. Oh, those were the days.
Reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of Jorge Torres. You may consider this fact in determining whether the actions of Sarah Boone.
Is Hannah out of jail, Team Brittany? And from the Rust case, is she out of jail? Did they let her out?
Goes on to say, we find at the time of the alleged second-degree murder, Sarah Boone knew that Jorge Torres had committed.
Right, your mom cherub art was very 90s.
Consider that fact to determine whether Sarah Boone reasonably
Love my cherubs. I love the little fat babies. My son got engaged, you guys. My son got engaged like last week in Ireland.
that the exhibits will be introduced
Made
into
that
evidence.
I really want the baby stage back.
They're demonstrative aids to aid the jury in understanding the circumstances surrounding that relationship and the actions that Sarah took and the reasonableness of those actions in light of their history.
Thank you. Any response, State?
Yes, sir.
Yes, sir.
Judge, the standard is, it is your discretion, and you will only be reversed if you abuse your discretion in this regard. The state is urging you just flat out, as a matter of principle, to not allow the parties to go into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. I mean, we can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during opening statements, but those things are all coming. So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary. Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that is from a body-worn camera, and I think he indicated as much. It was not from her phone.
I didn't have bloody ear on my bingo
If we
card.
get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established. And that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent,
Overt
which
act.
resulted in an imminent threat of great bodily harm or death. And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence.
That's right.
And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, then certainly A would come in some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not, a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C, D, E, F, G, H, I, state is all aware of those
JK,
photographs.
LMNOP.
We are prepared to introduce them ourselves. through the digital evidence. There's no hiding those things. If we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C,
It was C through I inclusive?
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. It's, I don't know, it wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, judge, absolutely at the end of the trial, great. Blow them up, use them as much as you want. But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Not as dangerous as playing hide and seek with Sarah Boone. But I like this prosecutor. I like him. He's very even-handed. He's very measured. And this judge is very learned and smart, and he's not taking any of it.
Mr. Owens, if you could address Exhibit B, it was pre-marked as B.
But Judge, you've already ruled that these things come in and open. Remember that? prior-
No, what I ruled is that you were able to discuss them, address them in opening. Photographs are a totally different kitty.
I said
Totally
nothing
different
about
kitty?
that.
Like kitty, like cat? Sharon says, I find it rude. The box is blocking the court reporter. Maybe she doesn't want to be on camera anyway. Maybe she's like, listen, I'm not camera ready this morning. I'm just going to let you leave this box here because I don't feel like being on the air. Couldn't blame her.
Spouse syndrome. I said self-defense. These exhibits come in. under
Different
self-defense.
kitty. Welcome.
Arguing.
Welcome,
these.
Jessica.
I've said nothing. about
Welcome,
that.
Law Junkie.
So I'm talking about self-defense.
I understand.
And prior difficulties, prior acts of violence is a standard instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
In good faith, with discussions with my client, we believe there is going to be evidence of an overt act. That she was facing imminent threat, and she reacted based on that threat.
Understood. Your response to Exhibit B.
Look at the, which one's the?
It's her on the
He
back
had it
porch with the two
coming.
dogs.
He had it coming.
Not only did he abuse, George Torres abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
I believe it is a part of the exhibit list. We got this from the state. This was they sent over a bunch
Oh,
of
they
pictures,
gave it to you.
flowers or paintings that they want to introduce, that they've listed as exhibits. I thought for sure we put this on there, but the relevance of it is not only did he abuse Sarah Boone, George Torres, he abused the dogs. And he would threaten to abuse the dogs to control Sarah Boone.
Don't worry, Salty. I think the judge also has a
Okay,
dental
Thank you.
degree, pulling teeth. He's also an oral surgeon.
The court's prepared to rule at this point in time. Thank you both for your presentations and your argument. The court's had the opportunity to what was pre-marked as A through I inclusive. First, with regard to the portion of the 3.9 instruction, purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You could talk about this is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to establish. But the concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be placed back into the tube, assuming that overt act hurdle is not met. The court, again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about specific some incidences made happen, but I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements. Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense.
No, sir.
All right, are we prepared to bring in our jury at this time?
Please.
They've been waiting for an hour and 20 minutes, Counselor.
Scott.
We intend to play the 2-minute suitcase video to the jury in opening statement.
Ooh, that's a risky move.
State.
Again, I'm asking you to urge your discretion. They're going to hear it in the next 2
It-
days. of
Yeah,
court.
but it's coming in.
It's
So I
up to
think
your
that's
discretion
okay.
whether
I
we're
think they
gonna
should be
hear
allowed
it
to
in
show
2 minutes of
that.
opening statement.
I
What's
don't
the
know why
other
they
issue,
would.
sir?
I need to approach the bench.
Okay. With regard to the video, I'm not going to allow proposed exhibits to be used in opening statements. It's good for the goose is good for the gander. I'm not going to allow your photographs, not going to allow the state to do anything. You can orally talk about what you believe the evidence and testimony is going to show, but the actual evidence is going to have to be presented here through witnesses or through demonstration and publication after that evidence is admitted. Y'all can approach.
While we approach, can somebody from their team start dismantling?
Please, I would appreciate it. Thank you.
Toothpaste wasn't on my bingo card. I may need to make a toothpaste emoji. I do have a Dr. Pepper emoji in the chat for members. I mean, yeah. So if you want to give it a test drive, the Dr. Pepper, when they mention Dr. Pepper during this trial, we can use it. Toothpaste. Scott worked at Roosevelt Field at World Imports. I just want to tell you that World Imports was my favorite store at Roosevelt Field. And I bet you anything, I was in that store when you were working in that store. How crazy is that? Any other Long Islanders who remember World Imports at Roosevelt Field? That was crazy. Cupcakes, hit the like button. Only 750 likes and it's 1,500 of you watching. 1,500 in the chat. Which is good considering there's a lot of other people streaming, streaming this trial. So thanks you all for being here. Thanks y'all. But yeah, hitting the like button is free and it really helps. Also share out the stream if you like hanging out here, like the community, feel free to share it out.
Any reason why we cannot bring in our jury at this time? State.
No, sir.
Defense. No, sir. All right, let's stand and bring in our panel.
Praise be. And here we go. We're getting closer. We got 879 likes and there's 1,487 of you here. It'd be such a nice thing for you to do for me. Sandra points out many contortionists are small, diminutive in stature. That is true. And George also was small, right? He was like 105 pounds. I don't remember his height, but you guys can tell me. Bring in the clowns. But the jury's not
Good morning,
clowns.
y'all may be seated.
Welcome, Jennifer. Jennifer Fashion.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yeah.
Can the parties approach for a moment?
No, they're not allowed to play the video in opening. Carrie, don't worry. Take the deal, Sarah. Sarah, take the deal. Sarah, if you took the 15 years, you'd already have credit for time served. You've already been in there for almost 5. Northwest, you are on it with my details. Would you like to be my new assistant? 5'2", 103 pounds. Was George, God rest his soul.
All right, members of our jury, good morning. I want to just confirm before we start this morning that you complied with the court's instructions last night to not have any conversations amongst yourselves or anyone else about the persons, places, things, or charge involved in this case. Then you have not conducted any independent investigation regarding those items. You just raise your hands to confer that you complied with the court's instructions. All right, the record will reflect that all jurors have raised their hands. Members of the jury, yesterday I told you that you may happen to see the lawyers in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you.
They're not
or
having
speak to you because
affairs.
they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense? All right, juror in seat number 3 from my left, first row. Yes, ma'am. Okay, thank you. Can you all approach for a moment?
Oh, okay. Yeah. So when you're an attorney, you are not
And
allowed.
a juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Do you recall who specifically, sir? Mr. Owens. Okay, thank you.
This trial is all zipped up, Mal says. You guys with the puns, you're amazing. You're so funny. As an attorney, when you see any member of the jury in the courthouse, you just turn around and walk away, just walk away. You don't go in the elevator with them. They usually have their own separate restrooms. You do not use the restrooms that the jury uses. It is improper to try and speak to the jury. So I think the judge is going to question the jurors now to see if while they were in the elevator with the attorneys, if they overheard anything.
All right, thank you both for your honesty. I appreciate that.
Hi,
Something we
Lori.
talked about earlier this week. That's the one thing that we required and asked of you is just be open and honest. And I appreciate both of y'all's open and honesty. During the ride in the elevator, was there anything that you saw or observed that it would impacted you or influenced you in any way to have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that, members of the jury, we're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses.
Stacey,
With that,
you don't need
Jay,
to
you may
rewind.
proceed, sir.
Thank you.
Nothing happened. It's just starting now. If you're late, you haven't missed a thing, except for motions.
The evidence this case is going to show you is that this defendant zipped Jorge Torres shot in a suitcase. She was able to do this because at the time of his death, he only weighed 103 pounds.
Get this man a mic. At least the closed captions has caught up. I apologize for Court TV's problem. It's impossible to modulate volume when some people have mics and some people don't. So rely on the captions.
She did this with the malicious intent to punish him. And then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 videos that the defendant herself took of this event. Evidence is going to show Jorge Torres is dead because in this defendant's judgment, he deserved it. Now, out of a conscious disregard for whether he lived or died, you will see and hear these videos. What I expect you will hear from a video that began at 11:12 p.m., 45 seconds, on February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah. The defendant will say, "For everything you've done to me." Sarah, "For everything you've done to me." Sarah, "Fuck you." And then the defendant laughs. Sarah, "Fuck
Beep.
you." And the defendant laughs. Sarah, "Stupid." Sarah, "That's my name. Don't wear it out." Sarah, "I can't fucking breathe, baby. Seriously." "Yeah, that's what you do when you choke me." Sarah, Sarah, Sarah. The defendant laughs again. Sarah, "I can't breathe, babe." She laughs again. "That's on you."
Get me stricken.
Sarah, "I can't breathe." She laughs again. Unintelligible words. And I would submit the evidence is going to show because of the intoxication from alcohol, is the next thing she says. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, fuck you. I can't fucking breathe, Sarah. You should probably shut the fuck up.
Thanks, Michelle.
Sarah.
Thanks, Michelle.
Shh is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound Jorge Torres is put into this suitcase left to die?
Go back to the mic, please, for the love of the traveling Mary.
This morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she doesn't see George anywhere, Torres, and eventually realizes, oh my God. The first thing she does after taking him out, and I believe you will hear a description by the defendant saying, took his little legs out. At some point she makes that statement. And tries to resuscitate him. Hears gurgling as she presses down on his 103-pound chest, forcing whatever air was trapped in there out of the gurgling. Then the next thing she does is she doesn't call 911. She calls Brian Boone. Who's Brian Boone? Brian Boone is her ex-husband. They share a child in common. And this date, February 24th, 2020, is a Monday. A normal work day for most people. School day for their child that they share in common. But after they got divorced, the arrangement was every other weekend, no co-parent. And that weekend included Friday, Saturday, Sunday. So it's that free schedule. And then Monday through Tuesdays, their child would be her responsibility. And Wednesdays and Thursdays, their child would be Mr. Brian Boone's responsibility. So February 23rd, 2020 was a Sunday. And now we've led into Monday, 2021. Mr. Boone had been trying actually to contact the defendant several times that morning because he just wanted to confirm she was going to get their child after school every day. And there had been a history of reliability issues on that issue on her part. So you will see in the phone record, he calls her, calls her, and calls her. Then she finally calls him back instead of calling 911. And being the nice co-parent that he is, he comes over. It's a short drive, 5 to 10 minutes. And as she's explaining to him what the heck is going on, he peeks in through the front door of her townhouse, which allows you a view all the way to the back sliding glass door. You're going to see that her kitchen is off to the right.
Okay. The court reporter is to the right of your screen. The blonde woman typing into the machine. I was wrong before. She's not behind the box.
Right, there's a doorway that you can see all the way through. Then on the back side of the kitchen and the breakfast room area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check please. You need to call 911. He doesn't set foot into that townhouse. He does wait outside though. being the good co-parent that he has been. So now, after having first called her ex-husband, after having first waited for Brian Boone to come over, the defendant makes the 911 call. What you will not hear are tears. You will not hear sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase and I fell asleep. He's not awake, he's purple, he's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And his body, like all bodies in suspicious deaths, was taken to the ninth division medical examiner's office in autopsy. What the doctor found was what you expect after being left in the suitcase, crumpled up in the fetal position. He passed from positional asphyxiation, meaning like you're not going to get full rest when you're crumpled up like an accordion, and environmental suffocation. You don't have to have a plastic bag over your head, tape shut with a full roll of duct tape to seal it off 100% and be worthy of the vacuum of space to environmentally suffocate. It's close enough if you can't get the oxygen and the CO2 coming in and out of your environment. But she also did notice, yeah, he suffered from blunt force trauma on his torso, in his face, his mouth. She'll use word contusion. Will help her explain contusions and bruises.
We need microphone accountability, says Manny Kranick.
Will help
Come.
understand for you all that that means bleeding under the skin and blood, what you expect from bruises, that's why they're running through. But he had all this additional trauma. He had trauma on his fingers as well.
He had trauma on his finger because she hit him with a bat.
The sheriff's office, Orange County Fire Rescue, and the defendant interacts with the first patrol officer. You will see and hear that body worn camera. It's more of the same of what we heard on the 911 call. I see. It was good. I fell asleep. I don't know what happened. A few hours later, the detectives from the homicide unit of the Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone off of a counter that was found at a suitcase by Mr. Torres, and giving it to one of their digital forensic examiners, who we'll hear from later in the trial. But it's time to give the first interview with the defendant. So they do a first interview with the defendant in one of their unmarked detective patrol cars there on the scene.
Thanks, dude.
And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were literally just enjoying one another's company. The other bottle of wine that was left over from Boer wasn't even half full. So the description she is saying is one bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect at a restaurant. Those are 750 milliliters of that. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters.
Oh, like a jug of
Opposed to
wine.
2 standard bottles of wine. A 1.5 liter bottle of wine is 50 ounces. Given that a standard serving of wine is 5 ounces, you can begin to do the math.
Hmm.
And there's receipts.
But
The day
wait.
before, Saturday,
you can do the math, but I don't know how many ounces are in 1.5 liters. You can't go from like metric to the other system. That's not smart. Dishonorable Kim Jong Kanone. That is the name of the morning. Thank you for that.
February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74.
At least it wasn't wine in a box.
And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are in fact Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class.
Are they wrestling?
Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine.
It's a lot of
So in
wine.
that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, and her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever.
It's going to be a good day. Still having a good time. Little fingers. Reminds me of the little tiny moccasins from the Robert Tellis trial. I just had to interrupt to tell you that. Remember the little tiny moccasins?
And basically, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it. Doing art, playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. 2 little fingers could stick out. And she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're not drunk. You will be able to assess that for yourselves when you hear the recording she made.
No,
No
I
ill
do
will
no, I
between
do
us
not
last night.
swipe stream other streamers. And no, please do not redirect my audience to other streamers. Thank you. I'm going to say it louder for people in the back. I would never restream another creator's stream. I just don't do it.
Last argument, maybe last week. Don't really argue. We came home, drink, smoke, did art, listen to music, play with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. And that's how that day ends with the police. She goes and sleeps and stays at her ex-husband's house the night of February 24th.
Sleeping at her ex-husband's house, really?
What they are doing, and by they I mean Orange County Sheriff's Office, in part, is going through her phone. That's when they discovered the two videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, like, we've been good. I've been good. She describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself.
This is too long and boring.
She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself. Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events.
Try playing hide and seek in a New York City studio apartment. If you know, you know.
At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over. I flipped him over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there.
They were both in the
When
suitcase.
she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before, though she described it happening before. I'll never drink alcohol again. She insists that she has no injuries on her, and you don't have to take her word for it because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words.
This
What
is
else is found on
too
it?
long and too boring.
There's a conversation between Mr. Torres's brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Ms. Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces and nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote unquote dad hit me in the face. The next text is, Hide and seek, I shall.
I agree, Karen. It all
January
went downhill.
13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh, Torres, referring to Mr. Torres, getting rid of. And that's the case. That's what the evidence is going to show. But we, the state of Florida,
Go back to the mic.
We're all going to come up to a door that says, danger, keep out, stay away, by court order. And that door says, the defendant's history with the victim. This is a door we shall not enter without permission and invitation. Halloween in like 13 days. Part of the vampire lore is vampires can't come get you in your own house.
I'm going to pause it while we can hear it anyway and thank Lisa Jernigan for gifting 5 memberships and Cat's Meow 420 for gifting 5 memberships. You're both very kind and generous. I appreciate you so much. And to those who are randomly gifted by YouTube, welcome. This opening could have been done in 5 minutes, and it really should have been because this is an open and shut suitcase, in my opinion. He's getting into the weeds now, and it's boring them. It's boring me.
We're going to be invited in to the defendant's past relationship for the previous couple of years. And as we come inside this room, at her beckoning, we are going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met the decedent, Mr. Torres, he smashes her phone, punches her. It's the first time in her life she'd ever been punched, I expect the testimony would be. And he made her curl up in a fetal position on her own porch for 4 hours. And she was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level was a 342 once when he got treated at the hospital. This is a man who has serious alcohol problems, and I expect you're going to hear about that. Despite that first date, and this is going to tie into some other things that I expect could possibly come in. Despite that first date, despite at that point in time of this first date not having a relationship, emotional ties, and the things that come along with a relationship that make it harder to break off a relationship, it's one thing to have a bad first date. It's another thing to end a 25-year marriage. Despite that first date, there's a second and a third. Now, these days are at bars, and there's nothing wrong with that. And it just typically ends up, she's going to tell you, I suspect, or you're going to hear that she said, one way or another. It's one thing or the other. Like, I ask a dude for a cigarette, Mr. Torres flips out, and I'm going to pay the price. Just things like that. You're going to hear and potentially see, yes, there were injuries that the defendant bloody ear, a stab wound in the leg, which is perhaps described as sword fighting playing around in that court. But nonetheless, I suspect you're going to hear and see a lot about their past history. And at the end, if this occurs, if this comes in, the state is going to have the opportunity to take lead of the tour in this room labeled the defendant and the victim's past history. And I'm not going to go into that now. If this all comes to fruit, the blooms on the tree during the trial, we'll discuss it at the end where it's more appropriate. But I'm asking you to not rush to judgment until you hear all of the evidence in the case. And then apply whether or not these past instances have anything to do with what happened on February 23rd. Now,
Even at the highest volume, I can't hear.
like a home inspector, there are experts to come in and kind of help walk everybody through this room labeled the defendant and the victim's past relationship. I suspect there's a chance you may hear from some experts, psychologists and psychiatrists, about battered spouse syndrome.
While you're bored, smash the like button.
Challenging in any way that battered spouse syndrome exists. Well recognized, the experts will tell you all about it. Not disputing that at all. But there's some things that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called DSM-5-ER. Diagnostic Statistical Manual, version 5. And I think it's text revision or something like that. What it is and what they describe it as.
He's starting to piss me off.
Component of post-traumatic stress disorder, PTSD. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder or diagnosis.
Nobody's more pissed off right now than the cameraman and the sound guy.
These three elements, like elements of crime, some of these elements have to be prevalent for a certain amount of time, so on and so forth. You imagine it's a cookbook. Gives you the recipe for a diagnosis. But because it's not in the cookbook, you may get some disagreement about what it means between experts.
Is he talking about the DSM? Suzanne wants to know. Did he just call the DSM manual a cookbook? Okay. Wake me up when it's over.
Kind of like grandma's recipe handed down from generation to generation without being right. But what I expect to hear is, it's important for people who don't have experience in certain abusive relationships that are violent to understand the control that can be exerted over an intimate partner by the other one, isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described for you as well by the defendant, perpetrated on her by the decedent. You will hear about all this. And what it ties into at the end of the day, after we talk about this during jury selection, is if
I'm checking long crime, but it's no better.
this is to help you understand what an objective and reasonable person in the circumstance.
No, Rara, he's on salary. He's a prosecutor.
Years ago,
So we'll talk to each other and just read the closed captions because it is annoying.
why don't you leave? And Battered Spouse Syndrome, the test
Exactly.
experts help
How do you take a brutal murder and make it boring?
not that easy. You got to look at what's going on in the relationship, isolation, control, so on and so forth.
Miss T says, my attention is completely drifted to that box. Wish it was taped more neatly. It's most distracting.
What you're going to decide the facts are is
Oh, all right. Fox 35, Orlando. Let's see.
Reasonable person in those circumstances taking those actions if you get self-defense instructions. That's what it's used for. It's not used for explaining the subjective beliefs that one holds. What you will also hear about these things is, just like any other doctor or any expert, like a home inspector. If a home inspector's report was based solely on the person who's trying to sell their house, what they say about the house.
Tell me if this sound is better.
Now, this is going to be.
I don't think so.
Things that the Fox on here, Carfax says. You want an expert to get reliable information.
Is this better?
The expert's opinion is only as good as the information that he or she relies on. They will say, yeah, you gotta take into account the credibility of the person who's giving you the story. Even if it's the patient or the client that is saying all these things happen to her.
No, her pumps are nude.
Particularly in circumstances that we discussed.
Dude, what?
Another thing that they're going to tell you is just because there's a bunch of violent nonsense going on between two different partners doesn't mean that spouse syndrome applies. Some people can go home and fight like cats and dogs, and that's just their day, and they get over it. They live their life and find another day. Their cycle just spins like that. So just because you hear about those things, what the experts will tell you, it doesn't mean that it necessarily applies. If this testimony comes in, I expect that Dr. Harper will say that it applies to exclude. But we'll talk to her about what she relied upon to make that conclusion. We'll talk to her about some other things and take that journey together.
We're going to take a journey together?
After you hear
Wah, wah,
all
wah.
the evidence in this case, particularly straight from the horse's mouth to the video.
You're calling Sarah a horse in opening? Oh, Sarah getting mad. Sarah's getting upset. He called her a horse. Who does
The
that?
evidence is going to show is that the defendant,
Wah, wah, wah.
Mr. Torres, because she decided he deserved it. Not because the evidence will show an objective, reasonable person in her circumstances needed to. Thank you.
Okay. The court reporter is not barefoot. Her pumps
you,
are
Mr. J.
nude. Look how
Any
pointy they
opening
are.
remarks by the defense?
Judge, can we invoke the rule? It has been.
I've already advised the witnesses.
Okay, the rule of sequestration will be invoked. Thank you.
All right. Meaning that the witnesses can't sit in the courtroom if they're going to testify. Oh, for the love of the traveling Mary. Really, dude? This is your moment to shine. This is your day in the spotlight. You answered this woman's ad on Craigslist to become her attorney so that you could gain some fame and fortune, and you're doing it pro bono. And for that, really, you're not going to find yourself a microphone so we can hear you? I just want to point out to you that that opening was over 30 minutes long. It should have been 5 minutes, 10 minutes tops. Hear what Owens has to say. If we can even hear it. If not, I'm just going to make jokes and put on the funny comments.
And I represent Sarah Boone, along with Tony Henderson and Kevin Beck.
The problem with this feed is we can't get the closed captions. So do you guys want to go back to court TV with closed captions? Because I'm here for you. Let me know what you want to do.
But trying to make arrangements for witnesses to find expert witnesses to talk about, and we'll know more probably.
Yeah, I think we need captions. Sorry, friends. I got to make an executive decision here. We're going back to court TV for captions. Thank you to the viewer who had the suggestion of watching the other stream, but it's crap. At least the witnesses, when they testify, are going to have mics at the podium, at the stand. Here's the thing: the microphones that are in the courtroom are for the courtroom. I don't know where the pool photographer put the mics. I mean, the most important thing is that the jury hears them, so nobody really gives a crap about us watching this at home. But they should, because, ratings, court TV, and law and crime, Fox 35. Oh, we're up to 1,100 likes. That's good. Sorry, but those of you who want to actually understand what he's saying, you're going to have to watch the screen. Lori Life 360, thank you so much for the Cash App.
Between Sarah Boone and George Torres. Sarah Boone and George Torres were down and out, as you can be. Their life centered around alcohol. Both of them suffered from, used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day, they struggle with the use of alcohol. You can imagine that. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other. And you're going to learn with all that was domestic violence. And that George Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years, and there were several prior incidences of violence. We've got the photographs. There were incidences where police were called who took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had, and considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's two sides to every story. You're going to hear the state's side, them attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that, all the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. Now let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time. Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that.
You and me
So it was
both.
in the refrigerator. Many times that's how they start their day.
Hi, sweetie. We tried Fox 35. The sound is not much better, and there are no captions, so we can't use it. But I appreciate you too. Please go back to what? Please go back to what? If you have earbuds, it's best to put them in. It's impossible to modulate the sound when some people have mics and some people don't. Fox 35 does not have closed captions, so the people that can't hear can't watch them. This is a living, breathing thing, live streaming.
At some point, you're going to see a video from Publix, from where they live. I believe it's Winter Park. But Publix was not too far from their apartment complex. And they took their car, they drove over there. So you're going to see a videotape from Publix of them both going in the store about noon. And they come out with one of those larger bottles of the wine. And then, of course, there's a receipt. And the bottles are in the garbage can. Of course, there obviously is an attraction between the two. And as everybody knows, couples can have great times where things click, everybody gets along, and then we can have episodes of disagreement. And how are those resolved? Really, that's what this is about. How are disagreements resolved? But George was very jealous of Sarah. And you're going to hear the testimony about that. And that he cannot, in certain situations, he can be very charming. But when his level of intoxication gets to a certain level, is when he gets sad, moody, and a lot of times eventually it involved forcible sex with Sarah Boone or actual physical violence.
Now they're bringing rape into it.
They bought the wine. It's a simple life. They don't have much money, but they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a convenience store right close by their apartment complex. And Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card, and he went over to the Publix and he got another bottle. And I think that was about 5:30, something like that. And again, there'll be the Publix video showing him going in, going out, and there'll be a receipt for the purchase of that bottle, and then there'll be that bottle will be in the garbage can along with the other bottle. Well, when he comes in with the second bottle, Sarah knows this is not good. She knows this means he's going to get to another level of intoxication. So Sarah's concerned. So she attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle, or she drinks as well. And at some point, they're intoxicated at a high level. As some people do when they're drunk, they get silly. And they decide to play a game of hide and seek. She goes upstairs, their bedroom's upstairs, to the shower and waits for a period of time. And he doesn't come to her. At some point, she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase.
He clarified it for me. They were going to donate the suitcase too. See, nobody understood. People are like, we would just throw our clothes for Goodwill into plastic garbage bags. But he says they're going to donate the suitcase too. Makes sense. Changing the story once again.
A large suitcase. They both weigh about 100 pounds.
She does not weigh 100 pounds.
Don't eat good. Malnourished to a large degree.
Maybe she did.
But the pull handle is broken off. And they've attached a little paper clip. It's got the rubber around it, and that's how they hold it back and forth. Well, she comes down the steps, she sees him getting in and settling in the suitcase. So she walks over there, and they see each other, they smile and laugh, and she zips him up. And she zips him up, and they laugh for a while. And they carry on. She sits on the couch. And at some point, he says, I can't breathe. Now, his face is facing the zipper, and she's got 2 or 3 inches that she's opened it. And she doesn't know. They're intoxicated. She doesn't know whether he's just saying that to try to get her to get him out or what. But he's a captive audience. Physically, they're the same size, but he's much stronger than her. If they got in a fist fight, he would win 100 times out of 100. But she's got him now. He claims he can't get up. He has to sit and listen. It's a unique form of physical restraint. And so she lets him have it. Says things she shouldn't say. You'll see the video. It's about 2 minutes long. She videotapes it. She sits on the couch and turns her phone on and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, the suitcase is flipped upside down. The zippers are off. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, Sarah. And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes. Okay? That is the key to this case. Sarah Boone will take the stand. She will explain what happened. She will explain why it happened. The evidence will show that she was justified in the action she took to prevent an attack from Jorge Torres, which the law acknowledges that every one of us has a right to invoke, the right of self-defense. You can hear from the medical examiner. She is going to tell you about some bruising on Jorge Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain, but there's some bruising. Sarah's going to explain that to you, why that happened, what were the circumstances surrounding that, involving the bat. Her son comes and stays with him from time to time. He has his own room. He has several of his things there, and there's a bat downstairs. The same bat that Jorge Torres used, and there's a video where George is threatening Sarah. and he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument, and he's trying to intimidate.
It's the only bat I could find.
Sarah loved you. You know, you're going to hear why women don't leave.
Why women don't leave. You're not going to hear it unless she testifies about the overt
Why
act.
women don't leave. And you're going to hear about Sarah Boone and her struggles, her mental health struggles. Sarah had no intent to kill. Prosecutor mentioned she wanted him to die. Farthest from the truth. She loved the man. She hated the abuse.
She loved the man. She hated the abuse. She couldn't leave.
She tried kicking him out 6 or 7 times. He kept coming back. She changed the locks. He kept coming back. She didn't have the family. She didn't have the support. She was weak, vulnerable. You're going to hear it all. You got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship. Now, you're going to find that Sarah's not perfect. And, you know, she goes, as many of us do when we drink too much, you sleep in. She slept in. 11, 12, 1, somewhere around there. She moseys downstairs looking for George. She thought he was on the computer looking for a job. She looked outside, maybe he's out smoking a cigarette, and she sees the suitcase.
If you didn't see that little movement of his, it was shock and horror. Come back to your screen if you didn't see this. His impression of when she sees the suitcase.
And she sees the suitcase.
Shock and horror.
She unzips it. She gets him out. He's purple.
Oh,
She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband.
right now.
She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house. And where her son is at? Lucas. It's the only thing she knows to do. She was kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls Brian. What do I do? He said, I'm coming over. Please come over. He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. He said, call 911. She calls 911 within a minute or two. Detective Rodriguez arrives. You know, they got the body cam now, so it's recorded. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible.
I mean,
eventually,
I think he's doing a really good job with what he has, in my opinion. He's more engaging than the prosecutor, which I didn't think was going to be the case.
statement to law enforcement. She gives one to Detective or Deputy Rodriguez. Of course, she's not the homicide investigator. She's just responding. She's the first responder. And, they know what to do. They try to assess the situation. They start putting the tape out, and then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars, and it's recorded. You may hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent, take the phone, take it to, they have a phone extraction people at the sheriff's department where they can take it and take out all the data, all your phone calls, text messages, photographs, videos, all of it. And they find these two videos. Sarah is not aware. She doesn't remember making the video. You can imagine. She gives them the phone. Well, she makes no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, Hobson is her name, Chelsea Hobson. And they end up, Deputy Hobson was pregnant, or Detective Hobson was pregnant. Said, end up, hey, we're not going to bring your phone. I'm not feeling good. I'm pregnant. Can you come to the sheriff's department? Which Sarah Boone was to tell you that was what I was going. That's what they told me I was going to the sheriff's department for. Well, instead, it was an interrogation. And they were going to arrest her. They made their mind up on it. And they were going to confront her and try to get her to confess based on the two videos. And
They're
so it was
allowed to do
approximately
that.
a 2-hour interrogation
We watched it.
that was on
It was more interesting than your opening.
in the afternoon when she got there to get her phone. They said, well, we got to come up here. We need to talk. And they got her in the room. It's a small room, but it's being videotaped and audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not.
Yep, suitcase in a box.
So she lies. She's not a lawyer. She doesn't know about self-defense.
But she
She
gets
doesn't
straight A's.
understand. She has,
Right, because she knew about, if she knew about self-defense, because she had straight A's and she was wicked smart. If she knew about self-defense, she absolutely would have crafted her interview differently. Don't point that out.
a lawful right to defend herself. She doesn't understand that she's justified in using the force that she used. She doesn't. I wasn't there to advise her. No lawyer was there. So she lied. And you're going to hear that. So you're going to have to balance that versus her taking the stand and testifying before you. And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you in reading the instruction on evaluating a witness's credibility.
Her narrative.
Talk about cooperative evidence, other evidence that's consistent with the testimony that Sarah Boone will give you. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack, but it was unconventional. Self-defense nonetheless. Now, as I said, the struggles that occurred, many of them involve the police. So you're going to actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. Police are there. So her attitude is not one of distress. You know, we're here today, full packed courtroom. Judge Graydon's here, but you're the most important people. Because you've got to decide this case honestly, fairly, and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case. But the most important thing is not to rush to judgment, to keep an open mind and understand there's two sides to this case. There's their side and there's our side. So you can't form any fixed opinions early on. That's hard to do, as Mr. Henderson said in jury selection. That's extremely hard to do. Now you're going to hear some testimony. There's been mention of experts. Battered women's experiences affect her perception of imminent danger.
Thanks, Maureen Gunn, for the super sticker.
Battered women's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not. After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty. Because it's the right thing to do.
Because it's the right thing to do.
Thank you, sir. Can
It's
party
the right
for a
thing
moment?
to do. We're a little behind, so let's catch up a little bit. Find her not guilty because it's the right thing.
State, you may call your first witness.
Okay.
State
What
you
that?
call Juan Torres.
Juan Torres, maybe it's a relative of George. I'm going to scroll the witnesses' names along the bottom, so if you're ever confused about who's testifying, just look at the bottom of your screen. Sometimes Court TV does not put their names on screen. It's kind of annoying. So you know, I'm here for you. I'm here to help.
Sir Morty, you could be seated.
Circle Morty.
Once seated, if you'd state and spell your name for the record for us, please.
Juan.
It says Circle Morty. You can be seated. Not Sir, good morning. You can be seated. Circle Morty. A new character has entered the chat.
Torres.
Catch Tori.
Good morning, sir.
Good morning.
Can you tell us how it is that you know George Torres?
He's my older brother.
And how many siblings do you have?
He's nervous. I feel bad for him.
6 or 7.
And how long has your family resided here in the Central Florida area?
20 plus years.
And before residing in the Central Florida area, were you guys in Philadelphia, Pennsylvania?
Yes, sir. In Massachusetts.
Your brother, how often, your brother George, that is, how often would you talk with him?
Often we talk, I'd say, on a weekly basis.
And how far away did you live from George?
About 5-10 minutes. Very close.
Would you see him pretty often?
I would try not to go there too much.
Who was George living with at the time that he passed away?
Wait, Sarah.
And without getting into many details, what was your relationship like with Sarah?
We wouldn't really have a relationship.
Would it be fair to say you didn't get along with her?
Yes.
Back on February 23rd, 2020, did you have an occasion to talk to your brother on that day?
Yes, sir.
And when you spoke with your brother on that day, did you FaceTime with him or did you speak with him over the phone?
We talked on the phone.
Was that phone to your ear or was that phone?
It was on speaker.
And who was present?
My wife and my 2 kids.
And without telling us anything that George may have said to you, can you tell us what the topic of that conversation was?
We were just talking like we normally did. He just calling me to check on me, basically.
Now, in the background of that conversation on the evening of February 23rd, 2020, what did you hear?
Sarah's in the background yelling.
And you recognized her voice?
Yes.
What was she yelling about?
Something about choking or how he choked her. I really don't. That was it.
He overheard Sarah talking about choking.
About how long was this conversation that you had?
Maybe 10 minutes, I think it was.
How did the conversation end?
Because she was yelling in the background, so that was it. We just hung out.
Did she sound upset?
She sounded upset.
Did you talk to your brother after that conversation?
No, that was the last conversation I had.
Oh. Northwest says the call ended with Juan and
Have
George
you
saying, "I
ever
love you."
spoken to Sarah since that conversation?
That's what he wanted him to say, but he didn't say it.
I have no further questions.
Any cross-examination?
He didn't say it right, Northwest? Kate. No cross? Sarah won't let him not cross. You know she's driving the bus. Oh, there's co-counsel on the defense side. Cool.
Mhm.
In the beginning, when you started, it was hard for me to hear. but I know you were talking about other siblings, other family members that you had here. Could you repeat that for me, please?
Here in Orlando, I have one sister and 3 brothers.
Sister and 3 brothers?
Yes, sir.
Okay. Now, did your brother George Torres, did he ever stay with you at any time?
No,
Would he ever live with you or any of, I mean, not you, but any of your other siblings?
no.
All right, sir, let's go back to this phone call that you were talking about that was on February 23rd of 2020. And that phone call was approximately 7:30. Is that correct?
Yes, sir.
And who called who?
He called me.
And then y'all were talking. Is that correct?
Sir.
All right. And when he called you, did you notice anything about his speech or his voice?
No, he was fine.
Sounded normal?
Yes, sir.
Okay. So he wasn't slurring his words or anything like that?
No.
By the way he talked or what he talked to you about, could you tell at that time if he had been consuming alcohol?
No, because I knew when he would drink.
Okay. So in your opinion at that time, based on what you heard and what he was talking about, you do not believe he had been drinking alcohol?
No.
Thanks, Northwest. This is not the
Now-
brother that beat up George.
You said
Mo
you
did.
heard Sarah.
Yes, sir.
Is that correct? How did you know it was Sarah?
I can tell in her voice.
You recognized her voice. So you could hear her. Is that correct?
Yes.
All right. And you've heard Sarah speak before that time. Is that correct?
Yes.
And you've heard her speak on the phone before that time. Is that correct?
Yes.
And you said that Sarah was yelling. Is that correct, sir?
Yes, sir.
And she was yelling about, he's choking me. Or tell him about choking me.
Yes.
Okay. During that conversation, and you heard her say that, did you ask your brother, what is she talking about?
No, I did not.
Did that statement at that time, did that statement surprise you?
Not really.
It didn't surprise you that she said she was being choked by George?
Before?
Hold on. I'm going to take that back because that's a very important statement for the defense. It didn't surprise him that he heard Sarah screaming in the background that he had been choking her. That's helpful to her case. I'm going to rewind that.
Not.
Did that statement at
No, I did not.
All right, hold on.
Did that statement at that time, did that statement surprise you?
That she was being choked?
Not really.
Interesting.
You've heard it before?
No.
Then why didn't it surprise you? Oh, you don't answer that question if you don't know the answer to it. Because he may say, oh, because she made
Based
stuff
on
up all the
Sarah's
time.
voice that you've heard, was it any indication to you that she had been drinking?
No.
No? Sir, at some point, your brother said he had to go, is that correct?
Yes, sir.
And did he hang up on the conversation?
Yes.
And did he say bye and you say bye?
Yes.
Thank you, sir. I don't have. If I can. confirm.
You may, sir.
He testified that it didn't seem to him like either one of them was drunk. And of course, Sarah is writing down notes probably and wants him to ask certain questions that he's going to go back and ask now.
Sir, other than siblings, your mother and father, do they live in this area?
Yes.
Were there times that George would stay with them?
Yes, sir.
Thank you, sir. No further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Defense?
Actually, we'll keep him subject to recall, Your Honor.
Okay.
I
All
would agree with that.
right, sir. You're released subject to recall by either party. Thank you.
Well, I think he was pretty neutral. I don't think he helped either side.
State would call Devin Jamro.
Fast forward a little bit. Wait a minute. Wait, stop. Hold on. Wait. You should give Shelby mature for more fruits. That's what the closed caption says. So now we have Shelby and we have Circle Monty. Two more characters have entered the chat. You should give Shelby mature for more fruits. I don't know what she's saying. Shall be the truth, the whole truth, and
Sir,
nothing
good
but
morning.
the truth.
You could take a seat and please state and spell your name for the record.
My name is Devin Jamro. That's DEVINJAMRO.
You found the
Thank you.
mic.
You may inquire, sir.
Sir, who do you work for?
I work for Public Supermarkets.
And what is your position with public supermarkets?
I am the assistant store manager.
And at what location?
Currently, the Castleberry location.
Were you at the location on Goldenrod and University Boulevard back in February of 2020?
Yes, I was.
Testing 1, 2. Testing.
Your Honor, may I approach the witness which has been previously marked for identification as States D and been shown to defense?
D is in Delta?
D is in Delta.
Yes, you may.
This will be the video of the wine purchase, I believe, or the receipt.
Sir, I'm showing you it's been marked for identification as States D. Could you use these scissors and open this and look at the contents of this package to yourself?
No, you see how they do this in Florida, folks? They don't do it that way in Massachusetts. He's going to open a sealed envelope that has maybe a disc of the video on it.
Those items. Sir, do you recognize those items?
I do. Yes.
And tell us, what are these items?
These are Publix receipts.
Are these receipts evidence of transactions at Publix? Are they made at or near the time of each transaction?
They are absolutely made at the time of the transaction.
And is it in the normal course of business that Publix keeps these receipts?
Yes.
And these fairly and accurately appear to be the receipts from your Publix store?
Yep.
Your Honor, at this time, I'd like to move what's previously been marked for identification as States D into evidence.
Any objections?
No objection?
What was pre-marked as States D will be received into evidence without objection as States 1.
Receipts for the magnums. Yes, wine yogi. Would you agree with me, wine yogi, that Woodbridge Chardonnay is like, oh, trash? I mean, if it's $9 for a
May I approach the
magnum.
witness, which has been previously marked for identification as states J and shown to defense?
You may.
Thanks, Deborah.
Sir, I'm showing you it's been marked for identification as states J. Can you take a look at that disc?
Misty and Eddie, we called him, Dewey. The closed caption said Misty
Do you
and
see your
Eddie.
initials on that disc?
I do.
Did you have an opportunity to look at that disc prior to coming to court this morning?
I did, yes.
And tell us, what is that disc?
This is CCTV footage burned from the camera system at the location.
And at Publix, is it the regular practice of Publix to utilize surveillance cameras?
Yes,
And in the normal course of business, are the videos from those surveillance cameras kept?
yes,
But are they inverted, sir?
And are these the cameras taken from February 23rd, 2020? And I believe there's 2 video clips included, one at 12:17 p.m. and another at approximately 5:39 p.m.
yes,
And they fairly inaccurately represent the surveillance video that was submitted from Publix to law enforcement in this case.
they do, yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states J into evidence.
Any objections?
No objection.
What was pre-marked as states J will be received into evidence without objection as states 2.
This is supposed to be so much
I
more
have no further
exciting.
questions for this witness.
Any cross-examination? Can this witness be released?
Yes.
Thank you, sir. You're released.
All right, so the
Have a
receipts
great
are going to
day.
go back with the jury. The video is going to go back with the jury. They're not showing it in open court, but they can look at it in the jury room. So there's that.
State, you may call your next witness.
State would call Joan Williams.
Why is he approaching to talk to the prosecutor? All right, we can FF a little bit, you guys. Remember the old tape recorder? The boombox had an FF button on it.
Ma'am, good morning. Could you state and spell your name for the record for us?
Okay.
Girl.
Joan, Joan Williams, Williams.
Thank you, ma'am. Counselor, you may inquire.
Good morning, ma'am.
Good morning.
Can you tell us what it is that you do for a living?
I'm a 911 call taker.
Oh, I love that.
And how long have you held that position?
24 years.
And tell us, what are your duties as a 911 call taker?
I answer phones for emergency, non-emergency, medical, which I transfer to the medical side of the business.
And is it the regular practice of Orange County to record 911 calls?
All lines are recorded.
And is it the regular practice of Orange County to keep records of each of those 911 calls?
Yes.
And those records are made at or near the time of each call, correct?
Yes.
Can you at least play this one
Your
in
Honor, may I
open court?
approach the witness, which has been previously marked for identification as states L and been shown to defense?
You may.
Ma'am, I'm showing you what's been previously marked for identification as states L. Do you recognize this disc?
Yes. My initials.
Did you have an opportunity to review this disc prior to coming to court this morning?
Yes.
And those are your initials on the disc?
Yes.
And does this disc, does it fairly and accurately represent the 911 call that you took in this case on February 24th, 2020 at 12:59 hours?
Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states L into evidence.
Any objections?
No objection.
This is how
Pre-marked
they
as
do it in
states L will be
Florida.
Received with no objection as states 3.
The witnesses initial
Your Honor, I
the
have
disc
no
they
further
watched.
questions.
Any cross-examination?
No, sir.
Can this witness be released?
Yes, Your Honor.
Thank you, ma'am.
You guys aren't going to play the 911 call either. This is going to be the most boring trial known to man. Everyone thought it was going to be
Parties approach momentarily.
so interesting, explosive, And so far, it's a big goose egg until Sarah Boone gets up to give her 3-day narrative testimony. Tan Suit Thoughts. Deep Thoughts by Jack Handy. I think a tan suit is very practical in Florida where it gets hot and humid, and perhaps you might not want to be sweating in your suit all day. Got to get a better look at it. We're on real time now, folks. Real time. And we're racing right through this with witness number 4 of the day after the most boring openings in the history of trials. As long as the tan suit is not linen, I'll allow it because linen gets too rumply, you know? Wrinkled.
Sir, you may be seated. After you're seated, if you can state and spell your name for the record for us.
Vincent Battaglia, Vincent Battaglia.
Vinny knows how to use the mic.
Sir, you may inquire.
Good morning, sir.
Morning.
Can you tell us what it is you do for a living?
Right now I work for an auto parts company,
And where do you live?
New Jersey.
Back on February.
Came from New Jersey.
2020, where were you living at that time?
I was living at the Tealwood Apartments in Winter Park, Florida.
And what were you doing at that time when you were living at Tealwood?
I was enrolled in Full Sail University. I was in school.
When you were living at Tealwood, did you have any roommates?
Yeah, I had one roommate, Brandon. Yeah, that was it. Them.
That's Brandon Motes?
Yes.
Did you have neighbors?
Yeah.
Were you neighbors with Sarah Boone and George Torres?
Yes.
And approximately how long were you neighbors with them?
About a year, a little over a year. I moved there in January 2019.
And during the course of that year that you were neighbors with them, did you have occasion to interact with them at times?
Yeah.
In fact, did you ever go over to their home?
Yeah, like a couple times, yeah.
And
Did you ever play hide and seek with them? Ready or not, here I come. Team Brittany says, I want a hot mic moment in the trial when that box moves ever so slightly and Sarah reacts. All right, there's nothing funny about this except you guys keep me laughing. Rest in peace, George Torres Jr. You didn't deserve
I believe
this.
you tuned a guitar for a child there at the house?
Yeah.
This Tealwood apartment complex, how would you describe the walls that separated your units?
Thin, like very thin walls.
Very thin walls.
And with those walls being so thin, would you ever have occasion to hear arguing and yelling coming from Sarah Boone and George Torres's apartment?
Yeah.
Did he ever hear him screaming in the suitcase?
How often would you hear this?
Almost daily.
Did Sarah Boone ever approach you about the things that you heard coming from their apartment?
Yes.
And where were you when she approached you?
I was smoking a cigarette on my back patio.
And approximately what time
It was
was this?
pretty late. I can't remember the exact time, but it was definitely anywhere between like midnight to 2 a.m., like right around there.
And do you remember how much before the date when the police called that this occurred?
A few months, like probably 4 to 5 months before that.
So 4 or 5 months before February of 2020.
Yeah.
And when she approached you on this late evening / early morning on that day, what did she tell you?
Pretty much just kind of like if I do hear anything like through the walls or whatever is out back, just kind of keep my mouth shut. Like don't really speak about it or anything like that or say anything to anyone. And I just was like, okay.
Did she make any
Through the walls came through the closed captioning as doodle was.
motions with her hands?
Yeah, like just kind of like, finger over the lips, like kind of shh, like keep it hush, like that kind of thing.
So she told you not to report anything you may have heard about arguments or yelling or fighting, anything going on over there?
Yeah.
Do you recall the evening of February 23rd, 2020?
I do, yeah.
And what about that evening sticks out to you?
That sticks out to me from that night was literally just there was a very, very loud noise that I heard that was loud and powerful enough to shake my bedroom wall. And I remember that because I was sitting on my bed on FaceTime with my girlfriend at the time, and I literally felt the wall shake and it stopped me mid-conversation. And she even asked me through the computer, like, what was that? And I was like, I have no idea.
Oh, I wonder if that was the
Did you hear
suitcase
any yelling
going down the
coming
stairs.
from their apartment on that night?
Before that, yeah, like it was just arguing kind of stuff.
What was the last thing you heard?
The last thing I heard was like the loud noise and just a little bit of shuffling, and that was kind of it. It just kind of went silent after that.
What time was it?
Did you hear anything that was being said?
Not clearly, and it was never really anything clear. It was just like you could hear arguing back and forth, just kind of like and kind of like an I hate you, like it's whatever it is, whatever the argument was about kind of thing. At the time, that's really all it was, but it was never really clear enough to hear like the full argument. And honestly, I never really paid attention too much to it. If I heard it, I kind of stepped into my living room to be further away from it.
Did you hear both the defendant's voice and also George Torres's voice?
Yeah, all the time. It was like a back and forth. Yeah.
So other than the statements and the phrases of I hate you, you weren't able to discern the contents of this argument?
No.
What was the last sound you heard?
The last sound that I heard was like the loud banging noise that
Banging.
it was like a very odd sounding noise that I've never heard before this day, but it very much sounded like it was where my bed was positioned. It was kind of towards the back of the apartment, and it almost sounded like it was coming towards me, but like on the side of me, then it was just like a loud rumbling noise. That literally sounded like it was kind of far away from me, and then it like ended up like almost next to me. And like I said, the walls are thin, so like it's very easy to hear like through the walls, and not even just sideways. Like I hear my upstairs neighbor, like all around, very thin walls.
Very thin walls.
was
He
your
can't say
bed-
that enough. Manny says I could never date Sarah Boone. She has too much baggage. I'll allow it says I hit him. Referring to the Karen Reed trial.
Room, where was it located in your apartment?
The back of the apartment. So it was like there's like a little kick out next to my patio, and that's like that was my bedroom back there, like along the grass back there.
On the first floor.
On the first floor, yeah.
I have no further questions.
Any cross-examination?
Oh, if Sarah's going to have a lot of questions for him.
Mr. Paglia, good morning.
Good morning.
Now, you said that you lived there next to Sarah Boone and George Torres for about a year.
Yes, sir.
Are you aware that the police were called to their residence
Like
while you were there for the year? Are you aware of any incident in which the police were called to their residence?
I had never seen anybody there, but I had had other neighbors in the complex tell me that it has been on
Objection,
multiple
hearsay.
occasions. So that's why.
Just instead of what somebody else told you,
How is there no objection?
just what you would observe. Did you ever, the year that you were there living next to them?
Yeah.
Were you ever aware that the police were called to their residence?
No, the times that I was home, I never saw any police at the apartment there.
And did you work odd hours or? You went
Yeah, and with my schooling and stuff too, I used to have class at like 1 o'clock in the morning. So all the time I was at random moments, like just not home throughout the day and night and stuff like that. So yeah.
Do you have an opinion as to whether or not, based on your interaction with Sarah Boone?
I'm going to object.
Let me finish the question first,
He
please.
doesn't get to talk about his opinion.
Do you know from your experience with Sarah Boone and your experience with Jorge Torres that they drank alcohol?
Yeah.
Yeah. It's like, yeah.
I'll withdraw to that question.
Okay, thank you.
Yes.
Are you aware that they both consumed alcohol to excess?
Yes.
Thank you. Hold on.
Yes, sir, of course.
Prosecution's like, yeah, I'll let him talk about that.
Well, Vincent, I think you had testified, you may have given a statement to law enforcement,
Yes, it was one of the detectives.
a recorded statement.
Yes, I can't remember his name, but yes.
Okay, and I think it was on February 23rd of 2020.
Yeah, right around that time. Yeah.
I believe you had said that,
I'm going to object as to improper impeachment.
Approach.
So you can't impeach a witness unless they testify to the opposite of what it says in their statement. Like there has to be a reason for you to use the statement to impeach them. He can't just bring up things that are in the statement that haven't been talked about because that's improper impeachment.
Objection's overruled for now.
sir, would it be fair to say on that date you got home around 7
7P or 7A?
p.m.?
7 p.m.
Yes.
Which day was this?
Sunday, February 23rd, 2020.
annoyed with
No,
him.
that day I actually got home from work probably around 1 or 2 o'clock or so.
In the morning?
No, in the afternoon, because I went to work that morning at around 5 a.m.
And you said that you heard the normal yelling and arguing at about that time when you got home?
No, it was around that time, but it was really around like 10 o'clock, 10:30 is when like the arguing I could really hear clearly. It was like around 10:30 at night.
Okay. Thank you.
That escalated quickly. If he just started hearing the arguing at 10:30 at night, and the videos started happening around like 11-ish, 11:12 or so.
Thank you.
Any redirect?
Just very briefly.
Yes, sir.
So
I
on
think
cross-examination, you were asked about the arguing you heard, and I believe your testimony was that it was pretty intense around 10:30.
Yeah.
Approximately what time was it that you heard this loud crashing thump sound that you described?
He didn't say thump.
Little after that.
Overruled.
It was a little after that arguing and stuff. It was probably around 11:15, probably 30, 45 minutes after like the arguing I could hear started.
No other questions?
Can this witness be released?
Yes, John.
I don't think he ever said crash
Not
thump,
subject to
but
recall.
I'll allow it.
We would like him subject to recall. You've got his number.
Okay.
Your Honor, may we approach?
Yes.
I think I've had too much to drink
Have a
tonight.
great day. Thank you.
The state would call Brandon Moats.
Well, Vincent Pataglia came. He's a Jersey boy. He came all the way down to Florida, to Orange County, Florida, from Jersey for this, probably on the state's dime. Definitely on the state's time.
Thank you, sir. You can be seated. State and spell your.
Wait, here the closed caption says Shelby. So now we have Shelby. What was the last one? Instead of shall be the truth. Shelby has entered the chat.
Thank you, sir. You can be seated.
RAN.
Spell your name for the record for us.
Yeah, my name is Brandon Moats, BRANDONMOATS.
Thank you. Mr. Cacciatore, you may inquire.
Good afternoon, sir. Now,
Good afternoon.
can you tell us how it is that you knew Sarah Boone?
I moved into the apartment next door to her when I was in college.
And so, when was that you were in college?
I would have moved down here in 2019 and would have been there until like 2021, 2022.
So she was your neighbor at Tealwood Apartments, is that correct?
Yeah, it would have been Tealwood back then, yeah.
And did you have any roommates back then?
Yes, I was rooming with Vincent Battaglia.
And during that time, what were you doing?
Like,
as far as work and school? And
I was just going to school. During the time of this, yeah, I would have just been going to school. I don't think I would have had my job yet. I was just a student.
I like his fun hair too.
Did you have much interaction
Let's go,
with
Brandon.
the defendant or with Jorge Torres in this case?
Honestly, I avoided them as much as possible usually.
The honesty is infectious. Do you have any interactions with George and Sarah? Actually, I avoided them as much as possible, actually.
The apartment where you lived, tell us, how would you describe the walls that separated your units?
Yeah, I remember that my bedroom was like the front facing bedroom and our walls shared a wall with where their staircase was. So like the way the apartments were laid out, we had a 1-story apartment, they had a 2-story apartment. So they had a staircase running right next to the walls next to like our bedrooms.
That makes sense. That they would hear something coming down the stairs.
Would you ever have occasion to hear arguing and yelling going on inside of the defendant's apartment?
Yes, the walls were pretty thin. So if people were yelling, you could definitely hear it.
And how often would you hear arguments or disagreements going on over there?
When I first moved in, it was it was at least like once a week, to the point that I started tuning them out. Like I got good enough at just like not listening to them. They argued.
Wow, that's annoying.
Very,
You know
very
it's bad when
often.
college students are saying the fighting was extra and the noise.
Do you recall the evening of February 23rd, 2020?
Yes, sir.
And on that evening, could you hear arguing going on in their unit?
Not late into the evening, earlier into the evening, probably like 7, 8 o'clock that evening, probably like earlier on, I could hear arguing.
And where were you inside of your apartment?
I would have been in my bedroom pretty much all night.
Oh, thank you,
And
Northwest, for
your
pointing this out.
bedroom-
Northwest, are you the offspring of Kanye and Kim Kardashian by any chance? And Northwest points out, and this is a great point, for civilian average citizen witnesses, we should cut them slack for dress. At one point, Brandon was listed as homeless, which I think we now have to call undomiciled. But yes, I agree. I agree with you. And we try not to bash witnesses' appearances here. We just talk about demeanor. We don't like to body shame. We don't like to, make comments about sexual orientation or looks. We talk about testimony, believability, credibility, demeanor, whether you think they're telling the truth. So thanks for pointing that out.
Just so that we can paint the picture, where would that would have been, on the first floor or the second floor?
We had a first floor apartment.
Okay, so all the units or all the bedrooms were on the first floor.
Yeah, like I was saying before, we had a 1-story apartment, and then they next door had like a 2-story townhouse. So we only had the 1 floor.
It's like, what part of my testimony didn't you understand, man? I got to get back to work.
And at a certain point in the evening, did you hear a loud crashing sound?
Yeah, probably around 10:30, 11 o'clock that evening.
And can you describe that sound for us in more detail?
I mean, yeah, at literally, like I said, at like 10:30, 11 o'clock, it's the way their staircase was set up. I could, my bedroom, the top of their staircase would have been like above my ceiling. And it ends next to where like my roommate's apartment was. So I could hear something start above me super loud and then fall away from me like it was falling down the stairs.
Did this affect the walls that were between your two apartments?
Oh yeah, me and my roommate, I remember me and my roommate talking the next day about like we could literally like it shook both of our rooms.
Wow.
Did you ever have occasion to talk with the defendant about what happened?
I never saw her after that. She would have, yeah, I never saw her after that happened.
No further questions.
Any cross-examination?
Yes, me too. I hope Brandon has a home. Otherwise, I'm going to crowdfund for him to get a home because he's taking time out of his day to come here and testify in this trial.
Good afternoon, sir.
Yes, we will shoe shame.
Sir, you were asked by the state if you ever had any interactions with Sarah Boone or Jorge Torres. Is that correct?
Yes, sir.
And I think you said you tried to avoid them.
Yeah, I don't like drunk people, and they were drunk a lot, so I did not interact with them.
I don't like drunk
you
people.
Remember this interaction with Sarah Boone in 2009 when you woke up?
2009?
I would have been 9 years old in 2009.
I'm sorry, 2019.
Okay, stop. Best part of the trial so far. Finally, we have a little comedy. It's 2019, not 2009. I love this guy so much. I do too. All right, I'm going to rewind it because he deserves a little more than 15 minutes of fame. He's a good man. He took time out of his day to come here and tell the truth. And he hates drunk people. And that's why he avoided them, because they were drunk all the time. And he was a college student. Him and Jersey boy Vincent were college students. Love that.
Do you remember this interaction with Sarah Boone in 2009 when you woke up and witnessed Sarah?
I would have been 9 years old in 2009.
I'm sorry, 2019. Good catch. In 2019, when you woke up and witnessed Sarah sleeping on the concrete patio.
Oh, this may have been a slight misconception in how I said this. I never woke up and saw her sitting on the patio myself. That I would have seen her on the patio eventually, but it's not like I woke up and went back and saw her on the patio. This was my roommate relaying the story that she had fallen asleep on the back patio, and then I saw her.
So you did not witness that yourself, or did you see her?
I saw her asleep on the back patio. I was just clearing up the sequence of events there.
Okay, thank you. Another time, do you recall our interaction with Miss Boone when you were coming home from school and she was trying to talk to you and she seemed paranoid and rambling?
Yeah, I had gotten locked out of my apartment, so I was waiting on the steps waiting on the steps outside of my apartment for my roommate to get home. So she came up and started talking to me. I don't really remember too many details of what she was saying, because I didn't want to talk to her.
Was she drunk?
Yeah.
Okay. Do you remember saying that you believe Sarah was avoiding going into her apartment?
That's definitely the vibe. I don't remember what
Vibe.
she was saying, but like the vibe she was giving off was that she didn't want to go home.
The vibes were off, man. Love that. Rambling and paranoid.
I believe, and I just want to make sure that I heard you. You said that the first arguments.
We'd love
other
to
than
hear
the
you too.
boom, which was like 10 something. Initially, it was around 7 p.m. You heard arguing.
It would have, yeah, because it would have been. I remember that day I got home from class around 5, because I got out of class around 4:30 usually and walked home, so I would have gotten home around 5:30, and it would have been after I took, because I came home, I made myself lunch, and I took a shower, and then I heard all of their arguing. So it would have been about an hour and a half, 2 hours after I got home, so around 7 to 8 o'clock.
Okay. And during that time, when you say arguing, was it back and forth?
I honestly, I wouldn't really be able to say if it was back and forth. I don't know I wouldn't remember too vividly if it was back and forth. Or if it was
Let me
just
ask you
one
this:
person
Did you
yelling.
hear a male voice?
Yes, I heard a male voice.
Did you hear a female voice?
Yes.
Okay. Were they both loud?
Yes.
I would like to have Brandon and Vincent as neighbors. I think they would be great neighbors to
I
have.
can confirm, Jay.
Yes, sir, of course.
Even my mics are hot. Says no one's asking to see their previous statement before replying. The truth is so much
Thank you, sir.
easier.
I have no further questions.
Any redirect?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Subject to recall, Jay.
All right. All right, sir, you're released subject to recall. Thank you.
Let's go, Brandon. Well done, sir. Well done. Witness of the day, in my opinion, so far.
Can the parties approach?
Sarah is not eating a Pop-Tart or a peppermint. Give the girl a Pop-Tart and a peppermint, for Christ's sakes. You never turn down a mint. Never turn down a mint. Let the girl have a mint before she goes back into like the full-on prison after her conviction, which, is more likely than not based on the video alone, in my opinion. Yeah, right. They're getting another weekend in Florida. They're subject to recall. Today's Friday.
Members of our jury, thank you so much for your time, your attention, and your participation in this very important process.
Yeah.
It is 12:21. At this point in time, we're going to go ahead and take our lunch break. I'm going to ask that you return here no later than 2 p.m. so we can pick up at that point in time outside of here, 12 Alpha in the Orange County Courthouse. And I'm going to give you an instruction. You're going to hear this instruction a lot over the next couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see
No
any place
internet.
discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have any discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog.
Chat
With that, members of the
room.
jury, please leave your pens and your notepads on each chair. The deputy
Do
will
they still have
collect them.
chat rooms
We'll see
out
you at
there
2
on the
o'clock, and
interwebs,
thank
you
for your
guys?
service.
What? wonder if they're going to do any housekeeping. Hmm. No. All right. Let's go to the chat. What do you think so far? I think those openings could have been so much shorter.
State, anything we need to address? Events. All right, Ms. Boone, I just got a couple of inquiries of you, ma'am, before release. Are you satisfied with your attorneys so far throughout this trial? And are you on board with the strategy that they've employed so far in this trial? All right, thank you very much. We'll be in recess till 2 o'clock. Court's off the record.
All right. Court is off the record. We're in recess until 2 o'clock. I think, okay, modulate your volume now, everyone, so I can speak at a normal tone instead of my golf whisper. Very smart of the judge to say, are you satisfied with your attorney's representation? And she said, definitely. So the poll in the chat, let's see where we're at right now about whether or not you thought that she was going to fire her attorney by the end of this trial. I will end the poll now. Get your votes in. Get your votes in. But now the votes are going to be, you're taking something else into consideration. So, oops. We have, will Sarah fire her attorney during the trial? 61% say yes, 39% said no. It's relatively close. 1,800 voters. Thank you for voting. Make sure you vote, people. Make sure you vote. Let's go to the chat. Thank you. iPhone search happens for the 5 says, great couple of days of streams, Melanie. I agree this should be an open and shut suitcase. That's what I said. I said that. I coined that phrase. It should be an open and shut suitcase. Thank you, Amy, for the Venmo, for thanking me for what I do. Thank you, Sherry, for your Venmo, who says, sorry, I haven't been on a lot of the stream lives. My puppy broke 2 legs. Oh my goodness. Your puppy broke 2. Everyone send out prayers for Sherry's puppy. Oh my gosh. And she also has a severe head injury causing seizures. And now, oh my goodness. And a car slammed into your 100-year-old Craftsman home, but you're still here. Everyone, please send your thoughts and prayers to Sherry and her puppy. Her name, you spell her name Sheri. I'm so sorry. Thank you for the Venmo. You didn't have to do that. You're going through way too much right now, but that is very kind of and generous of you. New Hampshire woman says, clothes don't make a testimony, words do. Absolutely, New Hampshire woman. And you're one of the OGs, one of the original members. We've only had memberships for 1 year. T. Wade saw this and laughed. Hire Melanie. She sued God and won. Thank you for the deuce and your pithy comment. I like it. I like it, very witty. Hannah Laura Williams says, if Sarah walks and Ashley did not, I'll be pissed. Yeah, me too, Hannah Laura. Me too. Clinton Nix, sometime can you tell us about your acting career? I'd love to see you as a judge on Law & Order. So would I. I've auditioned for Law & Order, all of them, numerous times. I'm waiting for the call. Dick Wolf, call me. I'm right here. Here's the problem. There was a pandemic. Then there was a writer's strike. Then there was an actor's strike. And now, since all of those strikes had happened, it's just not as busy out there in the the New York acting world of film and television, because all of the actors that didn't work for so long, that are more, let's say, B-list, are taking smaller roles because they haven't been working for so long that they're willing to do bit parts on episodic television, and they're just calling them cameos. So for someone like me to get a job right now or a gig on Law & Order is less likely than it was before. But Dick Wolf, I'm still here. I've auditioned for Organized Crime several times. I am putting it out there that I think I would be a great love interest for Elliot Stabler. I think I would. I know I can do it. I mean, if not, you could hire me on the original Law & Order to work in the DA's office, maybe under Tony Goldwyn. If you know, you know, President Fitz, who took over for Jack McCoy, and Maura Tierney, who I also love, is now on the original Law & Order. See? So I would love it if they would call me. That'd be fantastic. And Clinton, again, with another 5, says that I'm his #1 commentator. Always classy, intelligent, gorgeous, and funny. Oh, you spoil me. Thank you. Thank you for tuning in and for coming in and paying to give me compliments. I mean, really, what's better than that? What is better than that, Clinton Nix? Any relation to Stevie Nicks? Oh, thanks, Jason, for saying that I'm the best and for being a deadhead and for throwing a 5 into the college fund for the twins. I appreciate you so much. Oh, Danielle, this I wanted to address. Danielle said, Melanie, I listened to 5 minutes of the Phelps podcast last night. I had to turn it off. This morning, after I did the bus drop off, I went down. I sat by the water. If you follow me on Instagram, you'll see the picture of where I was. And I listened to it, the podcast. This guy Phelps, I keep wanting to say Michael Phelps, but that was the Olympic swimmer, right? Who smoked the bong hits. And anyway, Phelps did a podcast. Episode 1 has just dropped. It is about the Karen Reed case, and he interviewed Turtle Boy and a lot of other people, including, I think, Jennifer McCabe, because that was in the trailer. I listened to it, and I really thought it was good and it was fair. Try to go back and listen to it in its entirety, and I was pleasantly surprised that it was a lot friendlier to the Karen Reed side than I thought it was going to be. So if you haven't listened to it, maybe that'll be your lunchtime assignment. Listen to it. Come back. We'll discuss. Well, talk amongst yourselves, and then we'll talk about it when we come back. Because I actually did like it. For those of you who don't know, I'll tell you where to find it. It's called, I'm a Spotify girl. It is called, let me find it for you. No, that's not it. Okay, it's called Crossing the Line with M. William Phelps Presents. It's going to be, it looks like, it's called 34 Fairview Road. Crossing the Line with M. William Phelps. It's about, how long was the podcast episode? What was the trailer? It's only about 43 minutes, so you do have time to listen to it during the lunch break. We are going to split this into 2 streams today because that way we get to take a little break. The mods get to take a little break. I just want to set up the automatic redirect for you. So it will teleport you seamlessly, hopefully, into the afternoon stream where you can hit the reminder if you're going to take a lunch break and then come back at 2:00 because we have a couple more hours of trial together, which is amazing. I like having a schedule. I like being on trial with you. Pat Lochran said, waiting a long time for this. Happy to be here from Mexico. I wish I was in Mexico. Pat, I wish I was in Cancun right now, but I'm not. Tara Christine says, I'm in a committed relationship with this chat and channel and has no desire to cheat. Aren't you the sweetest, the sweetest, the sweetest? Love you all. Yeah, please smash the like button on your way out to your lunch break. We're going to come back around 2, maybe a couple minutes before 2. All right. All right, my friends. I will see you at 2. And Yucca Valley Nan is also giving Phelps a thumbs up. I listen to Phelps weekly. He's great. I think those of you who may have seen him on Turtle Boy's show might have thought he was a little bit of a, I don't know. You can tell me what you thought. But from that interview as well, or the small piece that I saw of it, I did not think that it was going to be very favorable to the side of Karen Reed being framed, but I was pleasantly surprised. So go check it out. I'm off sync with audio and video. I don't know. I can't help that. I'll refresh my browser when I leave, but thank you for telling me. Talk amongst yourselves. Thank you, mods, for keeping it classy. See you all soon. Smash the like on the way out and then back on the way in. It's not hard. You could do it. Be cool, be kind, be classy. Peace. I'll see you in about 90 minutes. Do your homework. Bye, kids.